Court officer audible ಇದೆಯಾ?
ಕೇಳಿಸ್ತೆ.
Hello.
ಸಿದ್ದರಾಜು ಹೆಂಗ್ ಮಾಡಿದ್ರಪ್ಪ MFಗಳು ಯಾವಾಗ ಬುಧವಾರ ಗುರುವಾರ ಒಂದು ಜನವರಿನಲ್ಲಿ ಪೋಸ್ಟ್ ಬಿಫೋರ್ ಕೋರ್ಟ್ ಅಂತ ಮಾಡಿರೋದು. ಇವಾಗ ಪೋಸ್ಟ್ ಮಾಡೋರು ನೋಡಪ್ಪ 10 ತಿಂಗಳಾದ್ಮೇಲೆ. ಈಗ ಅವ್ರ ಮೇಲೆ ಅದೆಲ್ಲ ಈಗ ಶೋಕಾಸ್ಟ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕು ಅವ್ರಿಗೆ ಆಫೀಸ್ ಏನು 10 ತಿಂಗಳು.
ಹಲೋ. Hello. Good up, sir.
My lord, serial number 36.
Huh? Day after tomorrow is a Saturday. Monday. So what is that matter? MFA, MEC na MFA. Monday. So what is that order which is passed there? What is the High Court order? No, that order is that not to alienate. Not to alienate, how will prohibit from coming to that suit schedule? No, what is the suit for? No, what has happened to that suit? What is that order you are challenging here? What is that interim order trial court has granted? No, you should not interfere ಅಂತಂದ್ರೆ then they can interfere. What is that? Injunction is you should not interfere. Then if they are interfering, then you file in a contempt.
But we have already.
Now, what is that interim order operating against you, madam? This court has granted not to interfere. That's what if they are interfering in spite of this court order, you file in a contempt. What can after granting that interim order, what this court can get? Only that if there is a violation, you have to file in a contempt. Monday. Yes. What is that urgency, madam? There is an injunction order in your favor. What you have to do if there is an order which is violating? What is that remedy? If I grant an injunction order, what can I grant further? You see me. Tell me that what order I can grant tomorrow. No, if I grant an interim order in your favor, what else can I grant tomorrow? Tell me. There is an interim order in your favor. What order can be passed tomorrow? If they are violated, then you have to file in a contempt. Is it not? Yes. Hmm. Now, what is that suit for? Hmm. Hmm. What is that order passed by the trial court? Who has to pay? Hmm. You can't pay, what to do, Mr. That has to be decided finally, is it not? Monday, yes.
We have a proceeding tomorrow for the trial court. The High Court had given the stay for it, but since we have the trial court proceedings tomorrow, it can.
What is that matter?
It is interference by the BDM.
Huh?
BDM interference.
What is the suit for?
It's for permanent injunction.
What is that order passed by the trial court?
I mean, tomorrow it will be doing it. They have asked them to take on it.
You have to give in a facts. Tomorrow, you just ask what has happened to the trial court. What order you have challenged before here? Monday. Madam, what the order you are already having in a benefit of interim order? Yes.
Page number 1, serial number 1 to 12. Page number 2, serial number 13 to 22.
Yes.
Weeks time limit.
5. Yes, at the request of counsel for the appellant. It is a matter of 2 weeks.
Page number 2, serial number 13 to 22. Page number 3, serial number 23 to 25. Page number 4, serial number 26 to 32. Page number 5, serial number 33 to 36.
Number 26.
Number 29.
Please,
This honorable court, value of the appeal is below 1 lakh. Yes, motor vehicles matter. Yes, at the request of counsel for the appellant, need matter of 2 weeks.
Serial number 15, my lord. Serial number 15, my lord.
Serial number 36.
36. It was not heard already by. From the.
Wait, and the matter is called. Which is that file, Mr. What has happened to? I have to see that. Tomorrow I will say that matter has been heard by Chief Justice of India. Can I say? Without seeing that. Wait,
We just need to.
unless the court has stated that it is in a part, I have to see what is that order which has been passed. Yes.
Page number 6, serial number 37 to 44.
Serial number 41, my lords. May kindly be after Deepavali vacations, my lords.
Deepak, PR.
Yes.
My lords, I pray for a short accommodation, my lords, after the vacations.
Request
My
of
lords.
the appellant, read this matter after 3 weeks.
Much obliged, my lords.
Page number 7, serial number 45 to 53.
One more connected between.
Conservation Act.
1342.
Government counsel for respondent number 1. Because this appeal will be called along with that so.
Page number 8, serial number 54 to 58. Sonaka Shetty, we for appellate in statement.
Next time.
You are appearing for whom?
One period.
Respondent for 137. Have you informed other side? Yeah. Yes, at the request of counsel for the respondent. Please- Interim order, interim order, interim order granted earlier is extended till next date of hearing.
Case number 9, serial number 59 to 65. Number 1 for orders regarding non-compliance of office objection, second time matter. Serial number 1, Exxon Joseph.
I have to the appellant.
Is granted to complain of possibility.
Serial number 2, this is Union Kuda.
Granted to complain the possibility.
Compliance of office objection, both time matter. Serial number 3, M. Surecha, Markanda Shetty.
I'm comparing now.
Yes.
I'm comparing now.
Yes. 2 weeks time is granted to compare the absences.
Serial number 4, Sarmati EI.
Statutory check deposit ಮಾಡಿಲ್ಲ.
Yes.
Last
Hello,
time-
ಅಷ್ಟೇ ನಾವು 1 to 13. Finally, 2 weeks time is granted to
Your Lordship, one submission.
Yes.
Only of the record that it has been satisfied. Your Lordship may dispose of and dismiss on the ground that non-compliance because of compliance has not been done.
Yes, you want to.
Without recording my submission.
Yes. In spite of 2004, in spite of granting in a sufficient opportunity, office objection is not complied. It's dismissed for non-constitutional. Bakidala 2 weeks.
Fifth time office objection matter. Serial number 14. Alakimaya KP.
5th time, finally, 1 week time,
Sixth time matter. Serial number 18.
1 week finally.
Order serial number 20. Group P for appellant. Granted matter to Mahesha.
Yes. There is a password.
The 19 MEC.
If this matter before the roster bench.
Number 22. Mahesha Shetty for appellant.
21, my lord, serial number 21.
21, no, this is not my roster. I think wrongly it is posted before this court.
Yes.
Serial number 22. Mahesha Shetty for appellant.
Yes. The next counsel for the appellant has filed a memo seeking dispensation of notice to R1. Memo. This dispensation. Where is India? Is there in Delhi? Is directed to take notice. Permanent counsel for the appellant is directed to serve 1 set of copies.
Number 23. PM Siddhamalappa for appellant.
Second respond, my lord.
Furnishing of PF is notice to who is second respondent?
Second respond, my lord.
You are appearing for second respondent.
Yes, sir.
Office objection raised on IA1 for written CCR other side. What is that office objection? Officer ಮಾಡಿದಾರಾ?
ಇಲ್ಲ ಮಾಡಿರೋ.
Where is that Sidmalappa?
PM Siddhamalappa.
540.
Serial number 23.
IA1 of 23 ಏನದು?
Delaying.
Written of TCR.
Yes.
That is not for return of TCR. If he wants to return the records, will return.
ಅಲ್ಲ ಹಿಂದೆ ಮಾಡ್ಬೋದು ಸರ್ ಬೇಕಾಗಿಲ್ಲ ಇನ್ ಕೇಸ್ ಆಫ್ ಡೆತ್
ಮತ್ತೆ ಅವ್ರು ಎಲ್ಲಿದ್ದಾರೆ ಅವರು? Where is Sidmalappa? Pass out. You get him. Get him in this.
Number 24. Notice case for appellant.
It has to be called along with that matter. ಅದ್ರಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತದೆ ಅಲ್ವಾ ಯಾರಿದ್ದಾರೆ ಭಾರತಿ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ
Ashok and Patil.
Yes, Pradeep is there. Yes. Pradeep is directed to take notice. Correspondent number 2. Net counsel for the opponent is directed to serve one set of copies on this matter along with the codes.
Well, I appear for the second respondent in both the cases.
Yes.
Well,
Who is, yes.
in the first case, my lord, it's by the claimant.
One of the vehicle. They are the claimant.
They filed a memo, my lord, before the tribunal to delete the, my lord, the Royal Insurance Company, and a considered order was passed. Now you are kindly look into, my lord, para 4 of my counter.
Yeah.
They filed a memo, my lord, deleting the, my lord, the Royal Insurance Company. Now, my lord, I request your worship to, my lord, LCR has come. The order may kindly be looked into, my lord, in LCR on 19/11/2014.
Now, what is that matter? First, let me understand that case.
Right. Claim for, my lord, the injury. In the claim petition, my lord, the petitioner counselor, claimant.
Insurance company.
Wait, Mahesh, wait. Yes.
Insurance company has been included with the claim tribunal. Subsequently, the claimant's appellant, claimant's advocate, for no reasons, filed a memo to delete the insurance company, though the insurance was the force as of the date of accident. The award has been passed against the owner. I have filed the appeal before this honorable.
Then
court.
matter has to go back. Why you have
Yes.
deleted, Mr.
And the previous.
Because they have no opportunity. Insurance company has to.
But moreover, my lord, he is stopped from doing pleading so. He's filed a
Why?
memo. You are kindly, my lord, look into the LCR, it has come. Order passed on memo. In MSC.
Previous bench has directed both of us to file
one
application
minute.
with insurance company. That application has been included. In view of that, the matter has to go back to the tribunal.
But
Since the insurance
I
company has
request the
not been
court to,
given
my lord,
notice.
look into the order in MSC 204 of 2012.
Sir, order dated?
Order on memo, my lord, on 19/11/2014. Memo, orders on memo, your of my kind
Yes.
thing, my lord.
Yes.
The advocate for the petitioner has filed a memo on 28/10/2014 with a prayer to delete the second respondent from this case, as the petitioner does not seek any relief as against the second respondent. Then, my lord, the last paragraph, the last few lines. Therefore, the memo filed by the petitioner can be allowed, permitting the petitioner to delete the second respondent from this petition. Hence, I pass the following order. The memo filed by the petitioner is allowed and permission granted to delete the name of the second respondent. Petitioner is directed to make necessary amendment in the petition and to file amended petition by 29/12/2014. He is stopped from, my lord, making an application in the appeal to implead the, unless that order was, my lord, it is by consent. on his own memo, and it is even otherwise it is not challenged.
Yes.
For the first time, they can't do it in the appeal because there is a collusion between the Malord, the claimant, and the Malord, the owner of the vehicle now.
Yes.
Owner of the vehicle has also preferred an appeal. That is MFA 3081 of 2018.
No, that are you denying that policy is not there in that vehicle?
My legal submission, my lord, when the petitioner made a memo and it was deleted, he is estopped from, my lord, pleading for the first time in appeal the second respondent insurance company.
Yes, that I will consider. I will consider that point.
Yes.
Yes.
He
Now
is
that it is posted today, what? Having so and so, IA filed for continuation of delay. What is that delay?
there is 797 days delay in, my lord, referring vehicle.
Filing.
Appeal,
Filing that appeal.
Appeal
Yes.
of, my lord, owner was 2018. As an afterthought, my lord, the claimant has filed this appeal in 2021.
Yes.
He was served in, my lord, 2018 appeal of the owner, and
Yes.
he did not take any, my lord, steps. Now,
Yes.
as a distinct, my lord, in 2021, he has filed a memo, appeal with a
Yes.
delay of 797 days delay. That
Yes,
shows
that will consider. Yes.
malafide on the part of the, my lord, and collusionness between the claimant and the, my lord, the owner.
Yes. There is a delay of 797 days in filing an appeal. A1 of 2021 is filed for condonation of delay. This appeal is filed by claimant. In fact, very same judgment and award has been challenged by owner of the offending vehicle, filing an appeal in MFA 3081 of 2018. Appeal has been filed within the time. That counsel appearing for insurance company has seriously objected for condonation of delay. There was that affidavit for reasons stated in that accompanying affidavit. Also, in the interest of justice, delay of 797 days in filing an appeal is controlled. The condition that the appellant is not entitled for the interest for a period of 797 days. Even if it is remanded, also you are not entitled 790 days. What is that next? Memo for withdrawal of that amount we will consider later as matters to go back. Then we'll post this matter for hearing. Are you ready, Mahesh? For hearing?
I'm ready, my lord, but the legal position, my lord.
That I will consider that. It is an appeal, continuation of the original proceedings. Court can so moto ask to implement. It is in a beneficial legislation, and you are not denying that there is no insurance policy. If they are collided, if there is no accident, all that has to be given by giving an opportunity for you. Without giving an opportunity, if I pass an order here, then it will affect your right. Otherwise, you can give an opportunity. We establish there. If there is a collision, if there is no accident.
Yes, my lord. Maybe posted for hearing, my lord.
Yes, we'll post this matter next week. Yes. I agree. For this matter. Hearing.
Along with IA for impleading.
IA for impleading allowable.
Illa.
IA is already allowed. Long back.
No, my lord. IA is not allowed, my lord. I find
after that only you have been made as a party, Mr. IA has been allowed by this court in earlier order.
Lord, in 6936, my lord. MFA 6936 of 2000.
Yes, after that only you have been treated as respondent number 2.
Lord, I have filed objection for impleading, my lord. That has not been.
No, I don't know that it has been passed by order. on 13/9/2022, this court has allowed this application by other bench.
But if that is so, my lord, the matter may be remanded, my lord, with an observation that, my lord, the
All contention will be left open.
left open, my lord, interest not, they are not.
That they are not entitled. That I made it clear.
Yes, may be remanded, my lord.
Yes. These two appeals, the MFA 6936 of 2021 is filed by that owner and claimant. So and so learned counsel appearing for the claimant has contended that in the first occasion, the insurance company of the offending vehicle has been made as a party. The claimant, by error, has deleted that insurance company, has filed a memo for deletion of insurance company as a party for the tribunal. The tribunal accordingly has been deleted party before the trial court. Since offending vehicle is covered with valid insurance policy, the insurance company is necessary party. Therefore, application has been filed for impleading the insurance company before this court. It has been allowed. Hence, he thought that matter may be remitted back to the tribunal for reconsideration. The net counsel appearing for owner of the offending vehicle has contended that offending vehicle is covered with valid insurance policy without impeding insurance company, without making insurance company as a party. The claimant has filed the claim petition.
But one more submission, my lord, that order was not challenged by the owner, my lord.
No, I will consider your submission. First, I will. The insurance company has been made as a party in the appeal. The matter has to be remitted back to the trial court for fresh consideration. O. Mahesh, learned counsel appearing for the insurance company has contended that the owner of the claimant himself has filed an application for deleting insurance company as a party. The tribunal, by order dated 6/12/2014, has deleted that insurance company as a party without challenging that order, without impeding. Now, they have stopped for therefore, they have stopped from claiming any relief against that insurance company. Or the learned counsel for the parties. There was judgment and award. It is not in dispute. The claimant has made Royal Sundaram General Insurance Company as a party before the tribunal when they have filed a claim petition. Later, the advocate for the claimant has filed a memo on 28/10/2014 seeking deletion of insurance company as a party in that claim petition before the tribunal. The tribunal, by order dated 6/12/2014, has deleted that insurance company as a party. And passed that judgment and award on 22nd December 2014. The same has been challenged by owner of the offending vehicle in MFA 3081 of 2018 has taken a specific contention that the offending vehicle is covered by valid insurance policy.
The order of
Yes, ma'am.
Mic mute ಆಗಿದೆ sir.
Mic mute ಆಗಿದೆ. Mahesh, mic. Your mic is muted, Mahesh.
okay. That
Yes,
order,
yes.
order was not challenged by the owner.
Yes, 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 that, yes. Really, Mahesh, have to do. That order is not challenged either by the owner or the claimant or petitioner. Has filed an appeal contending that offending vehicle is covered with valid insurance policy. It is insurance company has to indemnify the insured. Even the claimant has also filed an appeal challenging that judgment and award, and they have filed an application for impleading that insurance company as a party before this court. This court by order dated 13/9/2022 has allowed that application, pleaded that insurance company has a party. This appeal is a continuous proceedings of original petition. Also, the Motor Vehicles Act is a social beneficial legislation.
The principle of estoppel, my lord, against the
Yes, yes, yes. So, there is no bar for the appellant to seek for impleading that insurance company as a party. Only that insurance company has to be heard before passing any judgment and award. That is circumstances. Matter requires to be remitted back to the tribunal for reconsideration after giving an opportunity to that insurance company. Accordingly, the appeal is allowed. Judgment and award passed by the tribunal is set aside. The matter is remitted back to the tribunal with liberty to the claimants to implead insurance company as a party. The tribunal is directed to reconsider that matter afresh in accordance with law after giving an opportunity to all the parties without influencing any observation made in the impugned judgment and award. Now, who asked you to delete that, Mr.? You have created all these things to unnecessary burden of this court. Who has asked you to delete? Who is that advocate, Mr.?
but there was a settlement, therefore he deleted.
How can that advocate filed in a memo without the consent of that counsel? We don't know whether a settlement between whom. How can, Mr.?
Between the
What
owner
problem
and-
will arise if that insurance company has a party? Who is that advocate? Yes. It is also made clear that in case if claimant is succeed, claimant is not entitled for the interest for a period of 797 days.
One more submission, my lord.
Amount in the office is directed to refund that amount deposited by that.
Let it be paid to the claimants, my lord. Why?
Why your liability, if it is disputed, then only
Like that has to be decided, my lord. Now they have made an
See, if there is any contention saying that there is violation by the employer, then only. This is all part of that climate. Yes. Directed to be released in favor of.
May I request, my lord,
Yes, Mr. Mike.
Lord, after pleading, my lord, from that date, the liability will may not pay the interest if it is any, not for all these years.
That all contention is left open. You rise before the tribunal.
That submission may kindly be noted, my lord, because the tribunal will not consider it.
And also, he has contended that because of the delay, that even if the claimant is succeeded, payment of interest in respect of delay. Yes.
But the date may be fixed for appearance, my lord.
No, that you are not in a party. They have to file an application.
Please. They have made an application. It has been allowed, my lord. That's the reason why I made a submission.
No, only application only you are not in a party before the tribunal.
Let them.
Because in the past list, past title, it has been deleted.
Yes.
I to appear yes. Parties are directed to be appeared before the tribunal on or before 5th December. Yes, without any further notice. Nothing, Mr. It is all your point. Will not do it, put in a pressure on that officer. Yes. I don't know why that court has also permitted you to delete, Mr. ಎಲ್ಲವನ್ನೂ accept ಮಾಡ್ಕೋಬೇಕಂತಿಲ್ಲ. Court has its own discretion. Yes. Yes.
Court has observed, but not it is.
Court is directed to release in favor of that appellant in so and so after due verification. Yes. Already parties withdrew. What is the problem? Court can say that only a liability of the owner. If insurance company is all, let it be there in the party. Unnecessary, you are creating that litigation. Yes. That counsel for the appellant has filed a memo of this court to withdraw this appeal. Was taken on record. The above appeal is dismissed as withdrawn.
For second responder, please.
Yes. Yes, learned counsel for the appellant has filed a memo seeking leave of to withdraw this appeal.
Company felt the appeal is allowed 135.
Filed a memo on the ground that the insurance company has filed an appeal challenging the very same judgment and award in MFA number 135 of 2022 as disposed upon 23/8/2023. The memo dated 2/11/2023 is taken on record. The above appeal is dismissed as withdrawn. Now, if you want to withdraw that, why do you want all these things?
No, they are served and represented. All the respondents served and represented. How again I have.
If you want to argue on merit, it is different. If you want to withdraw it, withdraw it. That's all. On that only you have filed a memo, I recorded and they withdraw. Permission to office note. Yes, office note says the appeal is valid more than 15 lakhs post before the division. Council submission regarding that office objection. What is that office objection?
Office objection I made a submission. What before the court matter in January. They have taken 10 months to post the matter. A showcase notice has to be issued to the office. Why they have taken 10 months to post the matter before court?
The court shall see that all other pages of the Yes, what is this matter?
For enhancement of compensation.
Hmm.
Tribunal has taken income of 8,000, it has not added future prospects.
No, you are a claimant.
I am the claimant.
Who is appearing for legal sale Tata AIC Insurance? Huh? SV. Yes, SV agree is directed to take notice. Liability dispute idea.
ಇಲ್ಲ, liability ಇಲ್ಲ.
File a memo for dispensation. Notice to R1. File a memo dispensation. Sir, a copy taken instructions. Yes.
Number 31. Please to Telecast for appellate, that is the given in order.
Yes.
Respond number 1 will we have a PC Shivnagada I am representing. Owner ke KP Yoga and Pukala Takir. Owner
No, that you are appearing for whom?
and we have respond number 1 owner.
Again, liability dispute idea. Then owner has to be there. Who has filed an wakala?
KP Yoga has filed.
KP Yogana. Yes. What wakala is there? You are file ಮಾಡಿದ್ದಾರೆ. Yes. See, KP Yogana Learned Council suggests that he has filed a wakala for respondent number 2. Office to verify and show his name. Yes. What's the matter next week? Next week. Yes. Our the appearance bekala. If he has any this thing, ultimately liability has to go to that. Now that it has been on the owner. Owner has not challenged.
Owner is not challenging.
Yes. Leave this matter next Thursday.
Please, my lord.
Yes.
Number 32. Umashankar for appellate, connected matter, Chandra can speak.
Avoid service of notice.
Yes. Re-entertain the appeal for R1, R6 to R8.
Also taking to appear for respondent number R1, R6 and R8.
R6 to R8.
R6 to R8. Office is directed to show his name. Avoid service of notice to other respondents. What about the connected matter? Otherwise, you will take notice.
I take notice.
Yes.
8.
Abhinay Vaiti is to appear for respondent number 1, 6 to 8. Avoid service of notice to other respondents.
His grievance is in suit for partition that I have entered into a JDA with him. That's all. Agree for some portion he claims is entitled.
That is what that last occasion you have.
Do that and close it, my lord. Why
Yes.
keep the entire property undeveloped?
No. Last occasion, I think.
No, my lords have permitted the builder to sell his share. Out of 100 acres, my lord, it's one chick entitlement to the estate. In Ulji's property, I can't sell it. My lords have permitted him to sell the property. My lords have restrained me from not selling the property because he has filed a KVA.
Who?
The builder.
Builder has been permitted. Who are you?
I am the landowner, my lord.
No, you are the landowner. No, that is you are that you have given a GPS.
JDA.
In his portion, he has been permitted to sold.
My lord, they are entitled to a small portion in my share. My lord, special which are the apartments, we reserve it for them, subject to outcome of the sold.
What is that share he is entitled? You find out that share.
Entire extent, my lord, is 7 goods. Approximately, right, 6.5, my lord, it will be 7 goods.
No, even last occasion also he has agreed, showing that identify his portion and give it to you. Both of them sit and identify.
Easier, my lord.
Yes. Yes. Next week.
Next week.
Yes. Interim order granted earlier is extended till next date of the court.
Yes, 9th or 10th, my lord.
Any date, if both of them agree and move
9th or
it.
10th.
Yes. Identify it and move that. Yes, we'll dispose of it. Yes.
Number 36. Sampath for appellate, Sundara Ram to be.
Responded to this matter.
Yes.
There's some. Yes, we've got the appeal papers, but we'll file our objections.
Yeah.
And Lord, some of the documents which we had filed to the court below has not even been produced in this appeal. Some of the documents are missing.
No, there is no such provision to produce the
No, I
document.
want to place it before your lordship. So I'm not saying he's not. Produce some,
Yeah.
but not all.
Which
So,
is not.
what is not produced, I'll produce. That's all.
No, is there any urgency? Then we will hear for the urgency.
I think last time your lordship had heard for some time and then posted. Anyway, I would file objections to his application for interim relief. I don't know.
Now, where is
Since
that?
April of 2023, there's an interim order, my lord, which protects me. He files a suit, not disclose.
Mr. Senior Counsel, after hearing, I may reject his application.
Of course.
You
But
have to
I,
convince me that,
that's true. I only want to file my objections.
no, that, see, he wants to file an objection by next week. You want to make out urgency by next week, something will happen. Otherwise,
As it is the entire status quo of the subject matter of the property has been reduced by without, and there is a case, the
Well,
court
that-
takes a case in his favor. The defendant doesn't have any semblance of a case. It is
Yes,
court-
yes, wow, yes,
The
what is-
lordship was here on the last occasion.
yes,
Now this,
what is, yes.
is directed against the order of VA.
Who are you? Plaintiff for,
And will make it
yes, suit for,
suit for injunction, for suspension. Order that is being challenged is 15/9/2023.
yes.
There is a common order, that is IA number 1 is an injunction.
Hmm.
IA number 6 is the amendment. IA number 7 is the application by the defendant seeking modification of the interim order, which was modified on 24. Here is the case. And the appeal court of the entire social property.
Hmm.
Entire social property, there are as many as 29 apartments.
No, this appeal is against that which IA?
This IA number 1, it's a common order, which is available at page 37 to 39. By rejection of IA number 1, which is ultimately the present IA has virtually permitted the defendant to enter into possession. In fact, admittedly, as on the date of the defendant was not.
Wait, we'll come to that, mail. IA filed by the plaintiff under the CPC temporary injunction to restrain the defendant from entering plaintiff enjoyment of the suit scheduled property. Yes, where is that order?
Page 37.
39. Where is that final order?
Final order.
Page 61. 61.
Yes, I will come.
CPC.
61.
What is that? Yes, read. What is?
Now, IA number 1, page is read. Pending the possession of both the plaintiff and the defendant over the portion of the social property. Separate possession as the way to sue. In other words, possession of the defendant for fact number 29 $20, even 6 of the social property, along with the basic activity thereto, in the form of electricity and water connection and access thereto, including access by way of lift, along with unpartmented part, in the basement is protected and is there will be one say that it is in position. It is protected till the disposal of the written and the paint is restrained from interfering the difference position of the said fact number 29 2004 of the social property together with the person amenities and access to the same. Otherwise, there is a part of the however, and it is very clear that this order shall not come in the way of the plaintiff seeking ejectment, eviction, recovery of possession of the said portion of the social property to the process of the court and by filing a corporate proceeding.
See, here they have not said they are the owner. Now that question is, who is in the possession of the property?
Advisors, my owners, no position.
16/11/2009.
Now you come to the facts.
Yes, I'll come to that.
Yes. Then
Now,
who is the defendant?
defendant is person who was the joint owner with me
Yes.
of the entire property. Then admittedly, that is on 16/11/2013, both of them have purchased property.
16, 11, 13.
Yes. Jointly purchased the property.
Yes.
On the same day, the plaintiff executes, since he is out of value, he executes a GDA in favor of the joint owner. There is a defendant who take out the property. Then, admittedly, subsequently, the plaintiff found that he is unnecessarily interfering in the social property. The proposed vendor, he decides to cancel the GPA on 13/5/2014. Subsequently, whoever is necessary interference on 13.
No, you both are jointly purchased. Now wait, mister. You both are jointly purchased.
Yes.
You are the owner. Unnecessarily interfering with whom?
No, I
That you have to first tell who, with whom.
Why marketing? He's not a developer, he was a realtor. For some mistake, I had jointly purchased. Afterwards, on 13/2/2015, this is very, very important. The entire half share, the joint, right, purchased by him, by accepting consideration of 2 crores, he releases it in my favor.
By agreement. Yes.
Thereby, I become the exact owner of the property. Before that, on 13/5/2014 itself, I cancelled the GPO. This is something better. Now, thereafter, I approached the court on 6/4/2020. I filed it because there was an interference by him. Notwithstanding the fact that he executed illegally, he was trying to benefit the property because he had a power of attorney earlier, and there was a transaction.
Now what is the property?
It is a property, converted property, like residential apartment. 4 crore residential apartment is there. So, there of course, what has happened? When he started construction is going, he has nothing to do with that. Once he accepted 2 crores and released the entire property, he has no right and interest whatsoever with the entire property. So, when I was about to sell the property in favor of the proposed vendor, purchaser, he started interfering as if he has got some interest in the property, notwithstanding the fact that he had executed the release deed. This was the interference. I was away from bank. Then I find a student on 6/4/2023. I relied upon the release deed dated 32/2023. I have the actual owner and in possession of the entire owner.
Yes.
In that, on 6/4/2003, the court has considered the case of intention.
That is ex parte injunction.
Yes. Seek for modification of the Indian order without taking any challenge to his own release deed dated 32/2015. There is not even a counterclaim in my suit. He simply relies upon 3 documents. One is one gas connection. Admittedly, he is residing in the in an individual house opposite this property in Punjab. I come to it. On 19/4/2014, he might say, 19/4/2023, that is before the day of modification, he comes up with a court for modification. Before that, he files a complaint stating that we were 8 people in possession. In that, there is not even a whisper in the complaint to the effect that he is in occupation of any of the apartment. On the contrary, admittedly he is residing in an independent house. Then 24/2023, he files, he seeks a modification without there being a interim order, without there being a counter claim. He seeks a modification. That modification, the court.
Arguing the merits of the matter, or he's arguing the merits are in this one. I'm not interfering, I'm only asking you.
Papers, there's nothing. On 24/2023, he seeks for modification. What modifies that?
What is the reason given by the trial court to show that he is in the position?
Correct.
Now that
Now,
whether he
let me
is,
see.
now that whether he has given a release deed, that is
Nothing.
immaterial. Now the thing is proved for injunction. Who is the position as on the date of filing? What are the materials?
Now, your worship is admittedly as a defendant, he did not question 13/2015 release. All that he says, seeking modification, kindly see, there is not even a counter claim. By seeking modification, he relies upon 3 documents, which is available. I will read the very court order. I am not taking any other factual aspect.
Yes.
Kindly see, the court order 198 page. Okay, 10/2023.
98.
This is the order, first order which I have only said that I order passed.
No, that is the ex parte.
Yes.
Now that
Then,
what?
now kindly see 199.
You come to that impugn order. What is the error?
Let me, what does transpire? 99. The case is advanced. By the counsel of the defendant and taken to court, since the advanced part of the grade is heard on the grade, counsel is present. Counsel for defendant has filed legal statement in 2 sets, along with memo adopting the legal statement as objection waiver. He has also filed his document producing 9 documents. Counsel for the defendant has filed IA accordingly. Interim order is extended till the date of the hearing. Or counsel for amount prayer to modify the interim order to recognize the possession of the defendant over the terrace area of the social property. Now, in the written statement, there is not even whisper of contention to the effect that he is in possession of any portion of the social property. But on the other hand, he seeks the indulgence of the court to recognize his possession in one apartment. That is the object. Now, say 24/2020, this is the modified order, which is now in the impugned order. He seeks further modification. In the impugned order, he seeks efficacy 24/2020. Counsel for the defendant has filed additional also enforcing who attested to the person said to be neighbor and elder social property and producing a document. At this stage, it is not my notice that so and so has filed Wakala for defendant along with the advance certificate. But in the order sheet so and so, by interpreting the Wakala is not taken from the court and Wakala from this so and so. Counsel for the plaintiff has filed evidence to the plaintiff and listed documents with 3 documents. Heard both sides. Further on IA number 1 and requested the defendant want to modify the interim order granted earlier to protect the possession of the defendant in respect to flat in the 6th floor of the social property. At this stage, from the documents produced today, mainly the gas bill dated 24/2023, which shows that the defendant is in possession, and also the best form document which confirms the possession of the defendant in that flat in the top floor of the social property, and from the contents taken by the plaintiff itself in reply notice dated so and so, which is produced as a document of the it is prima facie appears that the defendant is presently in possession of flat bearing 29 and 64 of the apartment complex concentrated on the social property, and according to the interim order earlier dated is modified, holding that the plaintiff does not interfere with the defendant's access and possession to flat number 29 in the 6th floor of the social property and car parking area in the basement of and also the basic amenities including water and electrical. Now, at this time, let me make myself clear. Here is a case for none of the apartments. Now we are in the just got the occupation certificate. Nobody is in occupation. It is here operating in the temporary connection. Your lordship is well aware that the temporary connection is meant for construction of the building. It cannot be for occupation of the building. Now here. On the same day, the previous day, 24/2023, on 19/4/2023, he lodges a complaint He doesn't even say on the previous day, PCR files. He doesn't even whisper to the effect that he is in possession of any plant in the entire apartment. He says they were trying to disturb him. Taking advantage of this, the very next day he approaches the landlord seeking modification on the ground that he is in possession of flat number 29, and there is in the entire letter statement, he doesn't even whisper that he is in occupation of flat number 29. Now the gas bill, it is only a transfer voucher. Admittedly, he is in that area. On the opposite side of the building, he is in there. So here is gas connection. The next document he says, in some earlier notice, it was admitted that he is in possession of flat number 29. Now, ultimately, the legal notice that will fail into insignificance once he files a written statement. Written statement in the entire written statement, there is not the case. In that of the matter, is the court because now the actual order of the court giving him protection, providing him what connection.
No, see, according to you, even today is not in the position.
No, the dark of the court order, that is what I am saying. 19th court order, 6th court 2023 is the date of suit. Admittedly having possession. Till 19th court 2023 also. Even therefore, 2009 granted the injunction. On 19th quarter 2023, admittedly is in not in possession or carry of the fact. Now, in that case, and there is not even a whisper in the entire statement. That being the case, whether his contention, whether the court's order, how the court, notwithstanding all these things, ignoring the 2015 document, which is a consideration, for the court ignores it and modifies the order. That and after that, under the law of that order, he comes and occupies. Now, kindly see the entire 29 flats. Nobody is in occupation. We are not even entitled to operate on the list because it's only a temporary connection. We are now under the law. Very question, my lord, under the guard of court order. He himself gets into possession and he creates not only in occupation. I don't say that. But when it is not his case, when it is not at all his case that he is occupation of flat number 29, can he occupy under the draft of the court order and occupy? Am I not entitled to maintain the status as of the date of he is not in occupation, even according to his own way. Now, subsequently, by the way, we are in the story 24, 2023. He occupies. Subsequently, he files a suit against me. On 23 May 2023, which I have produced the thing. He tries to wriggle out of this because having taken and relinquished that. He files a suit. Right, this is page 207. At document number 11.
Where is that that water bill and something he has produced that document which relied on by that?
No, that is temporary connection. Temporary connection. Admittedly states in the name in my name.
It is not in his name.
No, not at all. And the issue order was the extent of it is not for the occupier. Construction purpose. I am getting to apply. This is about the temporary connection. It is with me.
I understand my learned friend trying to silence me, but you can't produce documents which is not there. First of all, you don't produce documents which I have placed before the
No,
court.
what is that Descom connection?
I'll show you lots of what is there. Can I pass on the notarized copy is just coming. In a legal notice issued by my learned friend's client prior to the filing of the suit, specifically admits I am in possession. All this argument I think is unnecessary because they have themselves in a legal notice specifically said that I am in possession of apartment number 29. I'm giving it up. Shall I give it?
One of them is produced enough.
Everybody said. Everybody. I'm good. Note it. Only nimshe read.
No, you are admitted. Then
what is there?
You answer that.
1 minute, sir. Our client.
No, I think you have better copy. This is not
Yes,
clear.
I'm sorry. I think my learned friend is a better copy because notice has come from there. Para 7.
Yes.
That is his stand. Prior to the suit, our client states that one of the penthouse is an occupation of the said N. Shiva Prasad. That is me.
Yes.
Who he has taken on lease from our client is not paying rent nor is vacating the same. In view of the same, our client is specifically instructed at Shiva Prasad to vacate the said penthouse and is warned of taking recourse to law to evict him from the said premises if not vacated at the earliest. Then there is said Shiva Prasad who some way or other trying to illegally occupy the penthouse, making all sorts of mischief and misdeeds against a client. And in fact, with the instigation and collusion of Shiva Prasad, one Krishnappa and others have filed suit against a client number so and so on the file of Honorable Civil Court. On the false and frivolous ground, where interim order was sought for, court did not grant.
No, what is that meaning, Mr.?
No, as far as that, I will. No doubt it was a.
As a matter, as a matter of fact, what trial court says, you came with a false case. You should have disclosed the fact that this property was in possession of Shiva Prasad. I should actually reject the entire proceedings because you came with unclean hands by not disclosing these fundamental facts. Your Lordship may appoint a commission. Look at the amount of work that has been done in the property. My interiors are done. I'm living there. I have a temple there. I'm Lord. I pray every day. I'm living there. My family is there. What he does is he disconnects electricity. Then there's a lift. He takes away the lift engine, the motor, and takes it away. I have replaced the motor 3 times now.
No, let him explain what is this.
So far as the, there is a notice in that it is not that on the basis of admission made by me. In that legal notice, he has set up any case either in that suit.
No, you
No,
got
that
it.
is it. Now, my learned friend is saying, that everything is now, my submission to your worship. Under the his own, now let me take my admission, or his own admission, as of the date of suit, that he is not a occupation to ignite. If at all he wants to take advantage of my admission in a legal notice issued at a prior point of time, he should have pleaded that case in the statement.
No,
He
you,
can by default, no.
no, you have come before the court.
Yes.
You have pleaded that he is in the possession. Are you entitled for that injunction? No, you answer that why you said that he is in the possession. If he is not in the possession, why you are asking him to pay that rent?
There is not even a scrap of paper. Here it
No,
was-
is it your notice or is it your notice or not?
100. It was in my notice, issued by an advocate, but admitted the mistake, whatever that has happened.
That is not your pleading anywhere that advocate without my instruction, he has given a notice.
Not disclose the fact before the court. Deliberately not disclose the fact.
Yes.
And this written statement, it is not now ultimately.
Mr. I'm in possession.
As on the date. He is not in possession as per the pleadings.
No, as per your pleading.
Pleading, I'm not in possession. It's the false pleading.
The court, how come now when nobody is
No, court need not rely on that electricity bill. This itself is enough
Sufficient.
for granting. No, that is, no, I am not on that, all this part.
That's what's there now.
No, now it is for a suit for injunction.
No.
Who is in the possession? We are not saying that he is a owner or it is not the case for title.
Yeah, lessons I want. Now the court order, I am saying, ultimately, what is making a case in his favor? This order, the effect of this order. Electricity should be provided, lift service should be provided. He has already parked so many cars. I have got also evidence which is on the drive that he is misusing our earlier point of time he was the joint owner. He is taking advantage of that. He is parking anywhere. That extent there should be modification. I am not, I am seeking anything wanted in this case. That's a different. But here, when the entire apartment, no apartment is occupied, when occupiers are not allowed to occupy, can the court permit him to occupy one apartment?
No, all that,
See, there is
no,
no
Mr. Illegal, legal will be decided later. When granting an injunction, person who is in the possession has to be protected. You have admitted. It is not that he has to be there in that. What is that other specificity?
He's meddling as if he's a builder, developer.
Yes, what is that other this thing?
Yes.
There's no such pleading, my lord. All of this is, the prayer is simple.
What's all the fact is challenging? How
Yes,
should the
yes,
people
yes.
get
No, but by shouting, my left hand can't silence me so completely. I also should get a chance sometime. Mr. Shetty may give me a chance.
I mean, see, it is not that he has to give after hearing that, when that court has a doubt, then you have clarified, let him to clarify these points, that's all.
Yes, but-
Otherwise that, if you allowed that counsel to argue, it is what that I have practicing. The moment I have any doubt, that has to be clarified, then it is finished. Otherwise that one counsel will argue in that morning session, other will be arguing in that evening session.
Correct.
Now that you have pointed out that main point, that he has to.
That, my left hand jumped
See,
that and gone to something
When
else.
he has argued, he under the impression that you have taking an advantage of the court order, he will interfere. By his own admission, now it shows that
That's clear.
now he has to answer.
Yes.
See, I will come to conclusion only after hearing that both the parties. Otherwise, that if he is hearing that under the impression that you have taking an advantage of the court order, you are entered. But it clearly shows that that was the intention. That was the advice of the earlier council that file an eviction suit. Now that there is an other
Change-
advice by the
Change and approach, but first get an injunction, then take possession. That was the idea, but unfortunately they couldn't.
Right, see, another aspect. Apart from that, he himself, he takes that 2 crores and goes, and then he himself enters into an agreement. Now, that's why it was
No,
no privacy.
I am not on that. I am also not on the final order of this court. Now that for an employee, now that for your application for stay is concerned, prima facie shows that he is in the possession.
Yes, possession, I don't dispute.
Now that you have also admitted that position, now you said that he has been permitted to do some other things. What is that? You have to
Yes,
find out. Don't go to that whether he has challenged or not. I am not. Can I decide now whether he has taken a 2 crores or not under all this?
He has entered into the agreement from 1960 after 13. He has surrender.
Yes.
He relinquished
Yes,
his
yes.
share. After that, of 1960 2015, he enters into, that's why I am saying, he enters into in respect of measuring 1,600 square feet for a sum of rupees 3 lakhs. Not in 1 rupees paid. This is what I am saying. Now, in that,
Yes, no, except that what is he is in the possession. Is there any other order granted to him to alienate or do it? What is that you have to find?
There are 2 injunctions. One is in his favor. It's a conditional order saying, while I protect you for everything, don't interfere with his possession and his right to use it. Electricity, water, I should have it, is what they're saying.
Now, in that, I have restrained, he obtains an order that 13/2025 order, 8 year, it is a novel document, and the court passes an order, the resident court, restraining me from alienating the entire system.
Where is that order? Have you
That
seen?
is already your file.
You
Order.
bring that, then I will see that.
Yes, sir. You are not sure. It is already filed.
Let us see that. See, now that position is clear. After he has given a relinquishment, whether he has been still given a right to restrain you from, that we will see that.
Yes.
That such an order can be passed. What is his right? All that,
No,
now
he
that,
has obtained an order. Now the court once under the grant of court order, he meddles with the property. And he obtains after this grant.
that doesn't correct. By seeing your notice, is it lawyer dreamt that he is in the possession or you have instructed the lawyer?
Lawyers,
How
can't
can that law?
can't blame the lawyer.
Admission is now any relief should be based on an admission. Now, even if it is on pleading, but there is no addition on pleadings for the court. He wants the fantasy, that is the
No, I understood that.
so called admission, he himself gives it up.
No, this is all
Fantasy,
that.
you are not stupid.
Yes.
MFA number six.
For this matter along with that. Up to and so.
2023.
Yes.
Serve the copy.
Seven.
Some,
What's may have it after immediately after Diwali, because 16, 16,
Yes.
wait, 16.
I will serve them the copy.
Yes. In that we will see what is his right to restraining due to alienating.
Now, order and court's order, court cannot have gone into that protection, under the guise of protection.
No,
If there is one
no.
agreement,
He
also, campus internationally, we have occupied the run party etiquette. Is it not right?
we will see that.
Law.
We'll see. Yes. Yes, probably.
Hearing interrogate application matters, serial number 34, submission by opponent.
The restaurant and final application for withdrawal of the.
Yes. What is that, this thing give a challenge? The quantum can be disposed of. Huh? Mic use ಮಾಡಿ. No, you are challenging only a quantum.
They have informed me, no,
You are faxing. Srishaila, what is that Srishaila says? It can be disposed of.
they can permit it to withdraw deposited.
By that two order, if there is only that I can dispose of.
You can post on Monday when I'm ready to argue.
You can dispose of this matter.
Main acceptable.
If they are not disputing that liability and all.
Only quantum it can be.
Quantum it can be disposed of.
Next week any date by law.
Next Wednesday.
Acceptable. Office. Acceptable.
Wednesday, Thursday. This matter on Wednesday.
35, is ready for appearance, present matter, Srinivasan Anmoy.
And for applying,
Quantum is negligent.
Hmm.
The doctor has taken a disability of 65%. Reduced to 50%. The other thing that my party has admitted in the class exam.
not during here.
No, you just argue that in respect of liabilities is concerned, we have considered
Right income is at 15,000.
50,000.
Accident you at 2013.
2013.
13,
2013.
6,000 income was taken.
6,500.
6,500.
6,500.
500. 2013 ಗೆ ಎಷ್ಟಿದೆ?
8,000 rupees.
8,000. Doctor has stated in that 65%.
ಎಲ್ಲಿದೆ ಅದು? There is a discussion, Mr. Srinivas.
Judgment page number 2015.
Judgment page 9, 889.
9. Yes.
889.
Yes.
Underline finally obtained the additional and sustained total 65% disability to its whole body.
What?
Yes,
ಡಾಕ್ಟರ್ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ?
65%.
ಡಾಕ್ಟರ್ ಹೇಳಿದ್ರನ್ನ ತಗೊಂಡಿದ್ದಾರೆ.
65 bed.
ಕೋರ್ಟ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 65.
65% has been considered.
ನೀವು now you are agreeing for 50.
50.
What are the injuries?
Injury is a severe head injury.
Injury. Fracture of involving
We
the
have weakness in right half of the body.
ಆಯ್ತು, now the disability we have considered for 50.
50%.
That I will reduce 50.
Another thing that doctor month through a
Now,
light.
now that income loss of future earning ಆಯ್ತು. Now that how many days he was in that hospital?
He was inpatient for a period of 40 days.
40 days. ಅದರಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
Pain and suffering 20,000.
Towards disability, pain and suffering 20 ಕೊಟ್ಟಿದ್ದಾರೆ.
20,000.
ಏನು as he both has agreed any this thing?
ಅದು ರೀಸ್ ಆಗ್ತದೆ. Due to Lordship, with 40 days inpatient and severe head injury,
Yes.
the doctor said that half of the portion is weakness.
Yes.
And food and nourishment only 6,000 was.
Yes.
Conveyance and food and
Conveyance
nourishment
charges
60,000.
ಕೊಟ್ಟಿದ್ದಾರೆ. Towards that income during the treatment period ಕೊಡಬೇಕು.
ಅದು 5,000 ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ. That is not awarded.
ಅಂತ ಅಂದ್ರೆ ನಿಮಗೆ 8,000 ಅಲ್ಲ ಇರೋದು.
ಹೌದು.
40 days.
40 days.
2 months.
Yes, 3 months.
Loss of immunity is not awarded.
Permanent disability, amenities ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ. Medical expenses, the doctor was said that every month he needs 3,000 throughout his life.
ಇವರು ಟ್ರಿಬ್ಯುನಲ್ ಅವ್ರು ಏನ್ ಹೇಳಿದ್ದಾರೆ?
ಇಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ ಏನ್ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾರೆ?
ಎಲ್ಲಿ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್? Why you needed that amount?
Correct.
Why you need every day that amount?
Weakness is intellectual requirement and psychological.
ಎಲ್ಲಿದ್ದಾರೆ ಡಾಕ್ಟರ್? ಎಷ್ಟನೇ ಪೇಜ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ? ವಿಚ್ ಪೇಜ್? ಕಾಪಿನಾ? ಸವಾಲು ಸದರಿ ಅವರು ಸಿಟಿ ಸ್ಕ್ಯಾನ್ ಮೆಡಿಕಲ್ ಗಾಯಾಳಿಗೆ ತಿಂಗಳಿಗೆ 3,000 ಔಷಧಿ ಖರ್ಚಾಗುತ್ತದೆ ಎಂದು ನಿಗದಿರುವ ಬಗ್ಗೆ ಅಲ್ಲಿನ ಔಷಧಿ ವಿವರಗಳು ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ನಮೂದು ಮಾಡಿರುತ್ತಾರೆ ಅಂತಾರೆ ಇಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ದಿನ ಇದ್ದಾರೆ 3,000 rupees ಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ?
ಅದೇ ಅವ್ರ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ರು 3,000 ಅಂತ.
It is still under the treatment, he would require medicine worth of rupees 3,000 per month ಅಂತ ಕ್ಲಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ ನೋಡಿ. ಗಾಯಾಳಿಗೆ ತಿಂಗಳಿಗೆ 3,000 ರು ಔಷಧಿ ಖರ್ಚಾಗುತ್ತದೆ ಎಂದು ನುಡಿದಿರುವ ಬಗ್ಗೆ ಗಾಯಾಳಿನ ಔಷಧಿ ವಿವರಗಳ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ನಮೂದು ಮಾಡಿರುತ್ತೀರಾ ಎಂದರೆ ಇಲ್ಲ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. Yes, that he has not written anything on that prescription that he required 3,000 every month. ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿರೋದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಅವರು ಎಲಿಸಿಯೇಟೆಡ್ 3,000 ರೂಪಾಯಿ ಏನ್ ಬೇಕು ಅಂತ ನೀವು ಹೇಳ್ಬೇಕಲ್ಲ ಡಾಕ್ಟರ್.
One submission, 2014 accident. Till today, they have not produced any document taken treatment for future medical accident. But daily
ಅವ್ರು ಮೆಡಿಸಿನ್ ಬೇಕು ಅಂತ
medicines ಬೇಕು ಅಂತ ಹೇಳಿದ್ರು, ಬಟ್ ಅವ್ರನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. Contributor negligence. Contributor negligence 20% has been deducted.
ಎಲ್ಲಿದೆ?
Cross examination of
He is admitted, my lordship.
ಎಷ್ಟು ಮಾಡಿದಾರೆ ಅವ್ರ ಮೇಲೆ?
ಅವ್ರ ಮೇಲೆ ತಗೊಂಡಿಲ್ಲ. Entire negligence has been declared.
10% ಮಾಡಿ ಅಂತನಾ?
I am asking, requesting to court 20% maybe contributor negligence maybe.
ಅಲ್ರಿ ಹೆಲ್ಮೆಟ್ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೆಗ್ಲಿಜೆನ್ಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇಲ್ಲ ಆಕ್ಚುಲಿ.
Lordship, suppose he is wearing helmet, he is not getting injury for head, my lordship.
ಅಲ್ರಿ ಅವ್ನು ಸುಮ್ನೆ ರೋಡ್ ಪಕ್ಕದಲ್ಲಿ ಇದ್ದನಿಗೆ ಹೋಗ್ಬಿಟ್ಟು ಆಕ್ಸಿಡೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟು ಸಾಯಿಸ್ಬಿಟ್ಟು ಅವ್ನು ಹೆಲ್ಮೆಟ್ ಹಾಕೊಂಡಿದ್ರೆ ಸಾಯ್ತಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು that is not, that's what Supreme Court, unless he has contributed. Anyhow, he has agreed, therefore I am not saying that not wearing a helmet. I will give other reason. Otherwise, this will be binding for other cases. That is not, Supreme Court said traveling with 3 persons, rebel riding, not wearing, unless it is contributed, it's not. But you can say that how that accident has occurred.
was riding two-wheeler.
ಏನು ಸ್ಕೆಚ್ ಇದೆಯಾ ಕೊಡಿ?
ಇಲ್ಲ, sketch ಅಲ್ಲಿ.
Yeah, that in the middle of the road it's happened, therefore 10% for him.
Lorry was dashed.
Yes, that's all.
And future perspective.
The perspective. What is his age?
25 years.
23 years.
23 years. 40%.
Yes.
Yes. Club ಮಾಡ್ಬಿಟ್ಟು Shri B. Pradeep Learned Council appearing for insurance company has contended that it is occurred due to the negligence of claimant in rash and negligent manner dashed against the lorry and that accident is occurred in the middle of the road. The tribunal is error in held that the driver of the lorry alone is negligent in causing that accident. He further contended that in respect of quantum, he has contended that even though doctors deposed that claimant has suffered 65% disability to whole body, he has not assessed physical disability. Considering that injury suffered by the claimant, the whole body disability is assessed by the tribunal 65% is on higher side. Further contended that the claimant was inpatient for a period of 40 days. He was not undergone any surgery. Yes. 40 days. Considering that evidence of doctor and injury suffered by the claimant, the compensation awarded by the tribunal, pain and suffering, loss, other incidental expenses is on higher side. Therefore, he sought for allowing that appeal filed by that insurance company. For contra, the Srinivasan Learned Council appearing for the claimant has contended that the accident is occurred due to the negligence of driver of the lorry. He was driving that lorry in rash and negligent manner from extreme left side and dashed against to that, from extreme right side and dashed against to that motorcycle. Motorcycle or scooter? Motorcycle. Immediately after, police has registered an FIR against the driver of the lorry and filed a charge sheet. Considering that evidence of the parties and material available on record, tribunal has rightly said that driver of the lorry alone is negligent in causing that accident. In respect of quantum, he has contended that due to that accident, claimant has suffered a head injury. He has examined the doctor. Doctor has deposed that the claimant has suffered 65% disability to whole body. Considering that injury suffered by the claimant and the evidence, medical records, the tribunal has rightly assessed whole body disability 65%. He further contended that at the time of the accident, claimant was aged about 25 years.
23 years.
And
23 years.
23 years. Due to that head injury, he was unable to do his day-to-day work. View of judgment of apex court in case of so and so, he is entitled for future prospects. Lastly, he has contended that due to that accidental injury, the claimant has suffered 65% disability to whole body. He has to suffer this disability and unhappiness throughout his life. The tribunal has not granted any compensation for loss of immunities. Compensation awarded by the tribunal, pain and suffering and other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Order the learned counsel for the parties. Even though matter is posted for orders on consent, it is not in dispute. Claimant has suffered an injury. The case of the claimant is that 13/3/2013, about 6:15 p.m. Petitioner was riding his motorcycle bearing registration number KA10 25509 along with that pillion rider. When they reached near Lakur village, the driver of the lorry bearing registration number KA05 C7997 came in rash and negligent manner, dashed against the motorcycle. Due to impact, claimant has suffered an injury. To prove the case, claimant has examined himself as PW1. He has produced 9 documents. To disprove the case of the claimant, the respondent has neither examined any witnesses or marked any documents. Considering that IME report and Mazur, very clear that the accident is occurred in the middle of the road. The driver of the lorry has came in rash and negligent manner, dashed against to that motorcycle. The rider of the motorcycle was riding that motorcycle in the middle of the road. Considering that evidence of PW1, IME report, Mazur, FIR, I am of the opinion that the claimant is also contributed 10% to the tax claim. Therefore, in respect of negligence is concerned, the driver of the lorry has contributed 90% to the tax claim. Claimant has contributed 10% to the tax claim. In respect of quantum is concerned, even though claimant has claimed that you are earning 15,000 per month, he has not produced any document to establish the same. Therefore, notional income must be assessed for the guidelines. For the accident occurring in 2013, notional income must be considered as 8,000. Due to the accident, claimant has suffered the following injury. He has examined. Dr. Nelly is a CW1 now. The doctor has been examined as CW1. In his evidence, he has deposed that claimant has suffered 60%, 65% disability to whole body. Considering that injury suffered by the claimant, and considering that evidence of the doctor certificate exhibit P6, I am the opinion that whole body disabilities has to be assessed 50%. The time of the accident, claimant was aged about 23 years. He suffered a head injury. He has to suffer this disability and anatomy throughout his life. This injury will affect his avocation. Therefore, in view of judgment of apex court, is entitled for future prospects. At the time of the accident, he was aged about 23 years. View of judgment of apex court in case of Pranay Sethi, 40% of the income of the claimant has to be considered for future prospects. Multiplier applicable to the age group is 18. Accordingly, loss of future earning has been reassessed as follows.
8,000 plus 3,200, that is 40%, 11. Into 12, into 18, into 50%, 1 lakhs, 9,000.
Due to that accident, unit has suffered the reversible injury. He was inpatient for a period of 40 days. He has suffered a lot of pain during the treatment. He has suffered a lot of pain during the treatment. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that the compensation awarded by the tribunal for pain and suffering has been enhanced to 3,000 to 60,000. Loss of income during the later period has to be granted for 3 months. Due to that accident, claimant has suffered a grievous injury. He has examined the doctor. Doctor has assessed he has suffered 65% disability to whole body. He has to suffer this disability and uneveness throughout his life. Then he is entitled for loss of immunities. 50,000 is awarded for loss of immunities. The compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, the appeals are disposed of. Judgment and award passed by the tribunal is modified as follows. The insurance company is liable to pay 90% of award amount with interest within 6 weeks from date of the
Deposit
amount in deposit is transferred to credit. Pending application. All pending applications are disposed.
Connected matter notice also pending. 35 rupees deficit.
R2 error. New. B. Pradeep undertake to appear for respondent number 2 connected.
Number 36. Disposal.
Application is filed for seeking some more time, extension of time.
ನಮ್ಮದೇ ಬರಲ್ಲ Available contents in-
Actually, last week ಅವ್ರ ಮುಂದೆ ಸಾಹೇಬ್ ಮುಂದೆ ಬಂದಿದ್ದು
ಹಾ.
ಬೈ ಮಿಸ್ಟೇಕ್ ಇವತ್ತು ಇಲ್ಲಾಗಿದೆ.
ಇದನ್ನೇ ಬೆಳಿಗ್ಗೆ ಯಾರೋ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು
ಹೇಳಿದ್ರೆ ಆದ್ರೆ ಪಾರ್ಟೆಡ್ ಏನ್ ಆಗಿಲ್ಲ.
ಅಲ್ಲ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅವ್ರ ಮುಂದೆನೆ
ಅವ್ರ
ಬರ್ಬೇಕು
ಮುಂದೆ
ಬೆಳಿಗ್ಗೆ
ಹೇಳಿದಾರೆ, ನನ್ನ ಕೊಲಿಗೆ ಹೇಳಿದಾರೆ.
ಡಿಸ್ಪೋಸ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ಏನೋ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅನ್ಲೆಸ್ ಇಟ್ ಇಸ್ ಸ್ಪಾಟೆಡ್ ಇಟ್ ಕೆನಾಟ್ ಬಿ ಬಟ್ ದಿಸ್ ಇಸ್ ಅನ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಆರ್ಡರ್ ಇಟ್ ಇಸ್ ಆಲ್ರೆಡಿ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ then it has to go before that same. Yes.
One day.
Yes.
One day.
The office is directed to post these matters before the application is filed for extension of the order dated 13th March 2023 passed by Justice S.R. Krishna Kumar. It's post this matter before the same judge on 21 Monday. Yes.
Number 37, Jagadish is for appellate.
Yes. Not pressed. There is no delay. IA 1 of 2020 is dismissed as not pressed. It is a claimant appeal or an owner? Why? What is that award amount? Why that policy was not there? Huh?
Policy was not there.
What not you are challenging?
The income taken is inside.
Yes, deposit 50%. Yes.
25,000 is deposited.
Huh?
25,000 is deposited.
No, that is statutory deposit. You have to deposit 50% of that award amount. What is that award amount? 5 lakhs. Yes. So notice stay up. Judgment and award dated March 15th May 2020. Passed by SCT Vasdurga in MEC 244 of 2018, subject to appellant deposit 50% of the award amount.
Claimant had filed 3 MFA earlier products, MFA number 170/14 and MFA number 230/14. Another MFA, 3 MEC cases were filed. They were dismissed. Again, the claimant filed the present MEC number 244/18. That's our awarding company. Earlier petition dismissed.
Why dismissed? There is no bar. You have taken that contention. After that, court has passed an award. Now that admittedly you have to pay that compensation. Only thing is that award amount is excess according to you. ಎಷ್ಟೇ ಕಡಿಮೆ ಮಾಡಿದ್ರು 50% ಅಂತೂ ಬಂದೇ ಬರ್ತದ. That you have to be even today or tomorrow you have to pay it. Therefore, if you want entry order, you have to deposit. Otherwise, I will issue only notice.
25%. It was already deposited 25,000 as deposit.
Allah, Jagdish, ultimately, your party has to pay because admittedly there is no insurance policy. You are not disputing that accident also. 50% ಕಿಂತ ಕಡಿಮೆ ಅಂತೂ ಆಗಲ್ಲ ಟ್ರಿಬ್ಯುನಲ್.
There are 2 vehicles, 2-wheelers involved. The other vehicle is not owner is the driver.
Have they filed an execution?
Government party ಮಾಡಿಲ್ಲ.
ಅಲ್ರಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಫೈಲ್ ಮಾಡಿದಾರ ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿಲ್ವಾ? ಹಂಗಾರೆ ಸ್ಟೇ ತಗೊಂಬೇಡಿ, ಸುಮ್ಮನೆ ನೋಟಿಸ್ ತಗೊಳ್ಳಿ. Don't you need not pay deposit anything. Issue notice.
I am for the appellant in this matter, my lord. I am not pressing the application filed under Order 5 rule, Order 5, my lord, of the Limitation Act.
Yes, IA 1 of 2020 is dismissed as first. Yes, you are a claimant or an
I am the claimant, my lord. Appeal for enhancement, my lord.
Notice.
My lord, LCR, my lord. Call for.
Why LCR? Let notice go. We'll see if it is necessary. Otherwise, you can dispose.
Please, my lord.
Here 1 of 2020 is dismissed as not pressed. Notice claimant. Upon dispense. Yes, notice to memo filed. Notice to R1 is dispensed. HDFC ಯಾರಿದ್ದಾರೆ? You are there, Mr. L&T General Insurance Company. For now that is become HDFC. You are there. Yes, B. Pradeep is directed to take notice. The counsel for the appellant is there. Sir, one set of copies on. Yes.
My lord, claimant appeal delay for 51 days. Delay, my lord.
Notice, Mr.
Much obliged.
Well, I am for serial number 42. I am for appellant. Well, I filed the appeal along with some IAs because claimant died and LRs to bring the LRs on record, set aside abatement, and to produce the death certificate. IAs are filed and also to permit it to prosecute the matter. There's a notice may kindly be issued on all IAs.
Notice on IAs. Yes. Notice. Once say, then you have to deposit entire amount. Yes. Issue notice. Yeah. Statement and degree dated 30th April 2022 passed by basically Chikkaballapura. Yes, Chikkaballapura in MEC 94 of 2014 subject to condition. Appellant has to deposit entire compensation amount within 4 weeks.
Number 44, Priyanka Pujari for appellant.
On the appeal, notice. Delay here. Huh?
There is a execution accident.
And your entire amount has to be deposited.
Second matter is there.
Hmm.
There are two claim petitions. In another matter, 10 lakhs were awarded. That time filed MFA 1588 of 18. There was a 50% stay order, my lord, 50% was qualified.
Hmm.
This matter, my lord, 47,119.
Where is that order? 50%. Why insurance policy is not there?
No, my lord, really transport endorsement illa anta. LMV is covered by Mukund Devgan case, my lord.
Or issue note. Pay of updated 9th December 2016 filed by MACT Harihara. Which is that MAC here?
Second, that is 903.
903 of 2014. Exert the condition. Appellant has to deposit 50% of the award amount with interest for a criminal within 4 weeks from today.
Number 45, R. Shashidhara for appellant. 45, R. Shashidhara.
Liability ಏನು ಇಲ್ವಾ? Dispute ಇಲ್ಲ. File for dispensation of notice to R1, dispensed at the risk of the appellant. Reliance General. Reliance. Huh? Where? Patil, you are there, Reliance. Patil is directed to take notice for respondent number 2. Learned counsel for the appellant is directed to serve one set of copies. Sorry.
46, Nagarada Young for appellant.
What is this, Mr.? Appointment of guardian. Memo filed by the appellant for dispensation of notice to R2. Why? Guardian has to be appointed.
Minor. It's about 7 years.
ಈ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರಿ?
Same also. Father appoint, guardian appoint ಆಗಿದೆ.
ಯಾಕೆ ಮದರ್ ಇಲ್ವಾ?
Mother ಇದ್ದಾರೆ ಸರ್, mother ಇದ್ದಾರೆ.
ಅಯ್ಯೇ number ಎಷ್ಟು?
46.
What is that age?
7 years.
IM 1 of 2023 is filed for appointment of the guardian. Around that, the claimant appellant is a minor. Father must be appointed as a guardian. Use that affidavit for the reason stated in the company affidavit. IA 1 of 2023 is out. The father of the claimant. What is his name? Claimant, the minor. The father of the claimant, that is Yogesh Loda, is permitted to prosecute this appeal on behalf of the minor. Yes.
What is maybe distance for R2?
Liability and dispute law.
ಇಲ್ಲ ಸರ್, ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ.
Notice to R1 is dispensed. R2 dispensed at the risk of the appellant. Future General India Insurance. Chunegowda is directed to take notice. The net counsel for the fine is directed to serve one set of copies.
Respondent. Yes, of
Yes. Back then? 15. Yes. Where is that discussion? Doctor ಹೇಳಿದ್ದಾರೆ
30%.
ನಿಮ್ಮಲ್ಲಿ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
5% has been considered. 2 days inpatient.
So, percentage of disabilities assessed by the doctor.
number 20.
Left to wrist, shoulder movement restricted, painful. Able to support, get up. Able to lift the weight, not able to rotate the forearm. Yes, what is the reason for reducing 5%, Mr. Pradeep?
He's taken 2 days inpatient, my lords.
ಆಯ್ತು ಇಂಜುರೀಸ್ ಇಂಟರ್ನಲ್ ಇಂಜುರೀಸ್ ಜಾಸ್ತಿ ಇದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ 30% 5% 1/3 ಆಫ್ ದ ಡಿಸಬಿಲಿಟೀಸ್ ಅಪ್ಲೈಡ್ 5-3-15 ಆಯ್ತು 1/3 ಆದ್ರೂ 5 ಹೆಂಗ್ ಬರುತ್ತೆ
10%.
Yes. Yes, madam. Then what is that income you have claimed?
They have claimed 50,000 rupees per month.
15.
150.
5 number.
Yes, can be correct, madam.
Tribunal has been considered 14,000 rupees.
Is that 20?
14,500.
2,500.
But they have not produced any document.
Pain and suffering, I ಕೊಟ್ಟಿದ್ದಾರೆ medical expenses 82. On the head, they have given sufficient. Yes, one more surgery. The estimation has been produced.
Oh, my lords.
Loss of immunities, future medical expenses. During the later period, that thing will put it corrected there. It is
25,000.
Yes. Interest?
Interest 6%.
Right. Also, learned council appearing for limit has contended that due to the tax dent, limit has suffered previous injury, was inpatient for a period of 2 days. Has examined the doctor as PW. 2. In his evidence, he has deposed that the claimant has suffered 30% disability. The tribunal has assessed whole body disabilities 5% is on lower side. The further contended that at the time of the accident, claimant was earning 50,000 per month. Tribunal has assessed the income of the claimant as 4,000 per month is on lower side. Also, she contended that due to that accident, claimant has suffered grievous injury. Doctor has assessed the disability 20%. He has to suffer this disability and NFNS throughout his life. Compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses, the lower side. Hence, he sought for enhancement of compensation. Contra, what's your name, Mr.
Mallikarjun Reddy, NA.
Mallikarjun Reddy. You can say that your name or yes. Mallikarjun Reddy appearing on behalf of Pradeep. Even though doctor has deposed that claimant has suffered 30% injury. The injury suffered by the claimants are doctor has deposed that claimant has suffered 30% disability. In fact, the injuries suffered by the claimants are minor in nature. He was inpatient only for 2 days. Therefore, tribunal has rightly assessed whole body disabilities 5%. Even though claimant has claimed that he was earning 50,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed personal income of the claimant as 14,000 per month. Also, he has contended that injuries suffered by the claimants are minor in nature. He was inpatient only for a period of 2 days. That evidence of doctor and injury suffered by the claimant. Compensation awarded by the tribunal for pain and suffering, loss of immunities, or incidental expenses is just and reasonable. Hence, he sought for dismissal of the appeal. Or the learned counsel for the parties. Because payment and award is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on F1/2020 due to rash and negligent driving of the driver of the car. What is the registration number of the vehicle? Car bearing registration number KA03 MQ2980. Due to the accident, claimant has suffered the following injury. He has examined Dr. as PW2. His evidence he has deposed that claimant has suffered 30% disability, 30% physical disability. Considering that evidence of doctor and injury suffered by the claimant, of opinion that whole body disabilities has to be assessed 10%. Even though claimant has claimed that was earning 50,000 per month, he has not produced any document to establish the same. But the circumstances, personal income has to be assessed as per the guidelines issued by not a legal service authority. For the accident occurring 2020, the notional income has to be considered as 14,500. At the time of the accident, body disability share number 10%. And he was aged about
27 years.
27 years. The multiplier applicable to that age group is 17. Accordingly, loss of future earning has been reassessed as follows. Due to the accident, Bennett has suffered the aforesaid injury, was inpatient for a period of 4 days.
2 days, my lord.
For 2 days. He has suffered lot of pain during the treatment. He has examined the doctor. Doctor has assessed the disability is 30%. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, declined to enhance the compensation for loss of immunities from 25,000. Loss of income during the later period has to be granted for 2 months. Compensation awarded by the tribunal in the other hand are just and reasonable. Hardly, the appeal is allowed in part. Not 6 days. There is a delay of 306 days. Condone not entitled for the interest. Of the order is not entitled.
48, BCC 1
Liability person on the person liability connected the insurance company, therefore
Only 50 against you. I'll challenge ಮಾಡಿದ್ದೀನಿ. Other 50 owner. Yes.
ನನ್ನ driving license ಇರಲಿಲ್ಲ. Therefore I am not liable until.
Yes. How
They are not given pay and recovery.
you sought for stay or notice only? Yes. How? Yeah. Order dated 4th May 2023. Filed by MEACT Bangalore in MPs 2341 of 2019. Take a deposit of 50% of the award amount. 50%.
Entire amount.
Entire amount of 50 because there is a delay. Yeah.
Serial number 48, Vivek Kumar.
Delay there. You have to deposit the entire amount.
For this quarter.
Yes, hard issue notice. They have order dated 16th March 20. Passed by MECT Mangalore in MEC 753 of 2020. Subject to deposit of entire compensation for this court within 4 weeks.
Serial number 50, action. Serial number 51, Pawan Chandra Shetty, as per appellate, Vivek Kumar.
Yes, where is? Pawan Shetty. Is it records necessary? Will Mandiria or admit number 52, 51, 52, 52.
Pawan Chandra Shetty, for appellate, has been acted.
Very well. Where is that Pawan Shetty? Nobody is there. Pass out.
It's a bet, sir.
OTL ಅಂತ ಓನರ್ ಮೇಲೆ ಮಾಡಿದಾರೆ ದಟ್ ಪೇ ಅಂಡ್ ರಿಕವರಿ ವ್ಯಾಲಿಡ್ ಡೈಸ್ ಇಲ್ಲ
Owner serve unrepresented.
ಸರ್ವ್ ಆಗಿದೆ ಕರೆಕ್ಟ್ 12 by note.
Yes, Mr. Bhaskar. That is the only point.
Enhancement as per the Lokadala chat, income has to be taken by note.
Liability ಯಾರ ಮೇಲೆ ಇದೆ? Owner ಮೇಲೆ ಇದೆ ಈಗ.
Owner ಮೇಲೆ ಇದೆ ಅದು
ಅವನು he has not challenged.
yes not pay and recovery ಮಾಡು ರಿಯಲ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ only
Yes.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಸಬ್ಮಿಷನ್ should 2 and 3
Hmm.
are majors ಆತನ ದಿಸ್ ಇಸ್ ದ ಆಕ್ಯುಪೇಷನ್ ಅವ್ರು ಹೇಳೋದು ಅಗ್ರಿಕಲ್ಚರ್ ಅಂತ
Hmm.
ಇದು ಸಾಮಾನ್ಯವಾಗಿ ಗ್ರಾಮೀಣ ಪ್ರದೇಶದಲ್ಲಿ ಮಾಡ್ತಿರ್ತಾರೆ ಕೇಳ್ಕೊಂಡಿರ್ತಾರೆ
ಯಾರಿಗ್ ಗೊತ್ತು? ಒಬ್ರೊಬ್ರು ಮನೇಲಿ ಒಂದೊಂದ್ ತರ ಇರ್ತದೆ. ಒಬ್ರೊಬ್ರು ಮನೇಲಿ ಒಂಥರ ಇರ್ತದೆ. ಅಪ್ಪಂದಿರೆ ಮಕ್ಕಳನ್ನ ಸಾಕಿಸ್ತಾ ಇರ್ತಾರೆ. Therefore, presumption is that he is earning at least as a daily wager. That is what the Supreme Court said. ಅವರು ಕೆಲಸ ಮಾಡ್ತಿರ್ತಾರೆ ಅಥವಾ ಅವ್ನು ದುಡಿತಾನೆ ಇಲ್ಲ ಅಂತ ಅಲ್ಲ. ಅವ್ನು ಸತ್ತೋಗಿರ್ತಾನೆ, ಇಂಜುರಿ ಆಗಿರ್ತದೆ, ಅವನಿಗೆ ಕಾಂಪನ್ಸೇಟ್ ಅಂತೂ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸತ್ತೋಗಿರೋ ಲಾಸಿಗೆ. ಅಟ್ ಲೀಸ್ಟ್ ದಿಸ್ ಮಚ್ ಯು ಕ್ಯಾನ್ ಗಿವ್ ಇಟ್ ಅಂತ. ಎಷ್ಟೇ ದುಡ್ಡು ಕೊಟ್ಟರು ಸತ್ತೋದವ್ನು ವಾಪಸ್ ಬರಲ್ಲ. ಆಮೇಲೆ ನೀವು ಡಬಲ್ ಕೊಟ್ಟರು ಕೂಡ ಅವನೇ ಮತ್ತು ಇದಾಗಲ್ಲ. ಅಟ್ ಲೀಸ್ಟ್ ಸಮ್ ಎಕ್ಸ್ಟೆಂಟ್ ದೇರ್ ಡಿಪೆಂಡೆನ್ಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಸರ್ವೈವ್ ಅಷ್ಟೇ. ದಟ್ ಈಸ್ ದ ಇಂಟೆನ್ಷನ್.
7,000 ತಗೊಂಡಿದ್ದಾರೆ 9,000 ತಗೋಬೇಕು ಇನ್ಕಮ್.
Yes, we'll come to that case of injury na death.
Death.
Yes, date of accident.
Date of accident
26/7/2016.
2016.
ನಿಮ್ಮ claim ಎಷ್ಟಿದೆ? 25,000.
Claim 25,000.
Tribunal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
7,000 ತಗೊಂಡಿದ್ದಾರೆ.
What is that?
7,40,000.
2016 ಗೆ ಎಷ್ಟಿದೆ?
9,000 ಇದೆ.
3,500.
10% future prospects of age.
What is his age?
55 years.
ಕೊಟ್ಟಿಲ್ವಾ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್?
ಕೊಟ್ಟಿಲ್ಲ 10% ತಗೊಂಡು. to 10,000.
ಆಯ್ತು, ಅದು ವಿಲ್ ಡೂ ಇಟ್. 1/3 ಕರೆಕ್ಟ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಇದು ಕನ್ವೆನ್ಷನ್ ರೇಟ್ಸ್ ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
50, 60,
ಆಯ್ತು, ದಟ್ ವಿಲ್ ರಿಅಸೆಸ್. ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಇಂಟ್ರೆಸ್ಟ್ 9% ಕೊಟ್ಟಿದ್ದಾರೆ.
That has to be 6%.
For enhanced amount
6%. There is that discussion regarding that driving license.
Current 12 minor. Current 12 of the judgment. The insurance also related to that is corresponding. Yes, on driving license. Yeah. Then
What is your submission, Mr. Rubis?
Heads ಅಲ್ಲಿ
Hmm.
ಮ್ಯೂಚುವಲ್ ಪೆನ್ಷನ್ 60,000 ತಗೊಂತಾರೆ, 70,000 ತಗೊಂತಾರೆ.
ಎಲ್ಲಿದೆ? ವಾಟ್ ಇಸ್ ದಟ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಯಾವ್ದೋ ಒಂದ್ ಕೇಸ್ ತೋರಿಸಿದ್ರೆ ಅದ್ರಲ್ಲಿ ಏನು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿದೆ, ಅದ್ರಲ್ಲೂ ಏನು ಇದಿಲ್ಲ. ಬಟ್ ಸ್ಟಿಲ್ ದಟ್ ದಿಸ್ magma is that division bench of Supreme Court has not been distinguished overall.
ಅದೇನೇ ಇವಾಗ ಅಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲೂ dispute ನಡೀತಾ
ಎಲ್ಲಿದೆ? ಯಾವ್ದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೆಡ್, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ said each one, therefore that Justice Nariman has explained consortium ಅಲ್ಲಿ what are the types of consortium: parental, spousal and filial. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೆಂಚ್ ಹೇಳಿದ್ರು ಕನ್ಸಾರ್ಷಿಯಂಗೆ 40 ಅಂತ. ಕನ್ಸಾರ್ಷಿಯಂ ಅಲ್ಲಿ these are all the 3 items ಅಂತ ಹೇಳಿದ್ರು. Then 40 were granting, even Supreme Court is also granting. ಯಾವ್ದೋ ಒಂದು ಕೇಸಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ಕೊಟ್ರು, ಅದ್ರಲ್ಲಿ ಏನು ನಾನು ನೋಡದೆ, ಅದ್ರಲ್ಲಿ ಏನು ಡಿಸ್ಕಸ್ ಅದ್ರ ಮೇಲ್ಗಡೆ ಯಾವ್ದೋ ಒಂದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನೋಡಿದ್ರು, ಅದನ್ನೂ ತಂದು ನೋಡಿದೆ, ಅದರಲ್ಲೂ ಏನಿದೆ. ಇವನ್ ಟುಡೇ ಇಫ್ ಯು ಗಿವ್, ಐ ವಿಲ್ ಕನ್ಸಿಡರ್. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರೆ ಇಟ್ ಇಸ್ ಬೈಂಡಿಂಗ್. Till there is a Supreme Court judgment, if you want to canvass on that point, I will consider only with supporting judgment. Yes, Mr. President. Dispose of. Yes.
ಅಂತ argued ಅಂತ.
Yes. So and so learned counsel appearing for claimant has contended that the time of the accident which was earning 25,000 per month. Tribunal has assessed notional income of the deceased as 7,500 per month is on lawyer side. He further contended that in view of judgment of apex court in case of Pranay Sethi, claimants are entitled 10% of the income of the deceased for future proceedings. Lastly, he has contended that in view of judgment of apex court in case of magma, claimants are entitled 40,000 each. Hence, he sought for enhancement of possession. For contra, the Westpur Learned Council appearing for this company has contended that even though claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 7,500 per month. Further contended that since the claimant failed to establish that income, tribunal has rightly not granted future prospects. Lastly, he has contended that in view of judgment of apex court in case of Pranay Sethi, the claimant is entitled only 40,000 for consortium. He sought for this of the appeal. Lastly, he has contended that the interest awarded by the tribunal 9% is on higher side. He sought for dismissal of the appeal. Heard the Learned Council for the parties. There was judgment and award is not in dispute. Alice died in road traffic accident. 26/7/2016 due to rash and negligent driving of rider of motorcycle bearing registration number AA13 EH680. Even though claimant has claimed that earning 8,000 per month, he has not produced any document to establish the same. The circumstances, personal income has to be assessed for guidelines issued by Karnataka Legal Service Authority. The accident occurred in 2016. The total income has to be considered as 9,500. In view of judgment of apex court in case of Pranay 10% of the income of the deceased has to be added for future prospects. Criminal has rightly deducted 1/3 of the income of the deceased for personal expenses. The time of the accident was aged about 55 years. Multiplier applicable to the age group is 11. Accordingly, cost of dependency has been reassessed as follows.
3,500 plus 50, 10%. 7,400. 483. 2,900.
4 ಜನ 4 ಜನ ಡಿಪೆಂಡೆಂಟ್ಸ್ ಇದ್ದಾರೆ.
1/3 ಮಾಡಿದಾರಲ್ಲ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ.
1/3 ಮಾಡಿದ್ದಾರೆ.
In all these aspects, in fact, the age of the deceased 55, time of so and so months. Who are that for?
Wife, two son and mother.
Mother, sons are major, they are not depending, therefore 1/3 has been made. Yes. Addition, 15,000 for loss of life, 15,000 for criminal expenses. View of judgment of apex court in case of magma. The first claimant is entitled 40,000 for spousal consortium. Claimant number 2 and 3 are entitled 40,000 each for filial consortium, parental consortium. Claimant number 4 is entitled 40,000 for spousal, the parent filial consortium. Enhanced compensation amount carries 6% interest. Area.
Delayed 416 days.
Yes, in view of order dated 10/2/2023, the appellant is not entitled for the interest for a period of 416 days for enhanced compensation.
Insurance, liability insurance. ಓನರ್ ಮೇಲೆ ಮಾಡಿದ್ವಿ.
ಅದೊಂದು ಕಂಟೆನ್ಷನ್ ಫಂಡ್ ಇಲ್ಲ, ಅದರಲ್ಲಿ ಅವ್ರದ್ರಲ್ಲಿ ಇನ್ನೊಂದು ಕಂಟೆನ್ಷನ್ ಫಂಡ್. Lastly, he has contended that the offending vehicle was covered with valid insurance company. Even though driver of the offending vehicle was not having valid effective driving license, for claimant is concerned, the insurance company has to pay that compensation amount liberty to recover from owner of the offending vehicle. For his contention, he has relied on judgment of apex court in case of Popo and bench of this court. Learned counsel for insurance company has contended that admittedly, driver of the offending vehicle was not having valid and effective driving license. Insured has violated the policy condition. Insurance company is not liable to pay any compensation amount. So, tribunal has rightly exonerated that insurance company. In respect of liabilities is concerned, the finding of the tribunal that driver of the offending vehicle was not having valid and effective driving license. The insured has violated the policy condition. The insurance company is not liable to pay that compensation. However, in view of judgment of apex court in case of Popo and bench of this court, in respect of third party's interest is concerned, insurance company has to pay the compensation amount in first instance and has to recover from the owner of the offending vehicle. This company is directed deposit, liberty to recover from the owner of the vehicle. 6%.
Entire amount ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕೆಳಗಡೆ entire amount has to be deposited by the insurance company. For the appellate minor, ಇದರಲ್ಲಿ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ. Kindly peruse the para 28 of the judgment. Disability as stated by the doctor to the upper lip 31%, to the right upper lip 31%, left upper lip 27%. But full body is taken by the tribunal is only 9.67%. The only issue for
Taking compensation,
Because
enhancement of the
the
compensation.
include is found to having disability of three, disability to whole body is 29.3. 29% ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. ಎಲ್ಲಿದೆ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್?
ಅಲ್ಲೇ ಇದೆ ಕೊಟ್ಟೆ ಸರ್.
ಎಲ್ಲಿ?
ನಿಮ್ಮ ಹತ್ರ ಕೊಟ್ಟೆ.
Right upper limb 31, disability to the left upper limb 27. Total ಎಷ್ಟಾಯ್ತು?
ಬೇರೆ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇನ್ಕಮ್ ಹ್ಯಾಸ್ ಆಲ್ಸೋ ಟೇಕನ್ ಬೈ ದಿ ಪೀಪಲ್.
divided by 4 ಅಂದ್ರೆ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಡಿಸಬಿಲಿಟಿ?
9.67 ತಗೊಂಡಿದ್ದಾರೆ whole body.
31 plus 27 ಅಂತ ಮಾಡಿದಾರಲ್ಲ.
ಫಂಕ್ಷನಲ್ ಡಿಸಬಿಲಿಟಿ ಅವ್ರು ಮಾಡೋ ಕೆಲಸಕ್ಕೆ ತೊಂದರೆ ಆಗತ್ತೆ ಅಂತ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. ಹಾಗಾಗಿ
14.5 will make it 14.5.
ಹಾಗಲ್ಲ, ಫಂಕ್ಷನಲ್ ಡಿಸಬಿಲಿಟಿ ಏನು, ಆ ಆಕ್ಸಿಡೆಂಟ್ ಇಂದ ಅವ್ರಿಗೆ ಏನ್ ತೊಂದರೆ ಆಗಿದೆ ಅಂತ ಅವ್ರು ಏನು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿಲ್ಲ. ಡಾಕ್ಟರ್ ಕೂಡ ಏನು ಹೇಳಿಲ್ಲ.
Then we'll see that evidence. Disability certificate. Yes. What's the evidence of
ಅಲ್ಲೇ Jana Nawaz.
relevant factor by considering that injury, find that petitioner is entitled. Now, what is the reason given by the tribunal, Mr.
Reason disability whole body.
Yes, Mr. Anup, what is the reason given by that?
Whole body, then ends of justice will be based on the.
Wait. Yes. What is that reason given by the tribunal, Mr. Anup?
ಅಲ್ಲ, ರೀಸನಿಂಗ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
On the other hand, they have said that you have not elicited any information from the doctor.
ಹಾಗಲ್ಲ, it is for the claimant to come before the court and establish what is his functional disability.
He has said and he has examined the doctor to reduce that. Tribunal has to give some reason.
ಅಲ್ಲ, ಫಂಕ್ಷನಲ್ ಡಿಸಬಿಲಿಟಿ ಬೇರೆ, ಫಿಸಿಕಲ್ ಡಿಸಬಿಲಿಟಿ ಬೇರೆ.
Functional disabilities he is entitled for.
It is for him to establish. ಅವ್ರು ಮಾಡೋ ಕೆಲಸಕ್ಕೆ ಈ ರೀತಿ ತೊಂದರೆ ಆಗತ್ತೆ ಅಂತ ಅವ್ರು ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ಬೇಕು, ನಾನಲ್ಲ.
Yes.
ಅಷ್ಟೇ ಸ್ವಾಮಿ ನಂದು. That is all.
There is that evidence of plaintiff. What is the name of the petitioner? Appeal and LT, I was more 50,000.
Punit,
Due to that injury sustained by him, he is not positioned towards my. But since I have lost my memory and even now I am taking the treatment, I have acute pain. Can't move without the support of others. So, that's a negligent driving of the own factors. Driver of the lorry. You are the driver. What is that your client was doing?
He's a businessman. Produce the document exhibit P26 and 27, claiming to be getting income of 25,000.
That person due to the ransom. It is a class examination.
fracture of numerous lateral rib.
Is the doctor evidence? Yes. That's all.
Okay, under
That's
the
all.
debt, I am seeking for an answer.
Please in that head. Yes. Senate Council for Senate has contended that due to the extent that Senate has suffered serious injury, he has examined the doctor as PW2. He has proposed that Senate has suffered 31% disability to right upper limb, 37% disability to left upper limb. The whole body disability is assessed by the tribunal. 9.67% is on lower side. Due to that disability, he can't do his day-to-day work. Therefore, he sought for enhancement of compensation under the head of loss of future income in the disability. The net council appearing for the insurance company has contended that the injuries suffered by the claimants are minor in nature. The disability is assessed by the doctor will not come in the way of his day-to-day work. The claimant has not established that he has suffered any loss due to that disability. Therefore, tribunal has rightly assessed the whole body disabilities 9%. 9.767%. Hence, he sought for dismissal of the alternate counsel for the parties. And he has contended that interest awarded by the tribunal 8% is on the higher side. Alternate counsel for the parties. Judgment and award is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 2018 due to rash and negligent driving of driver of lorry bearing registration number A01D2906. Due to the accident, the claimant has suffered the following injury. He has examined the doctor Vijay Kumar. In his evidence, he has deposed that the claimant has suffered 31% disability to right upper limb, 27% disability to left upper limb. Even in the claimant, in his evidence, he has categorically stated that due to that accidental injury, he was unable to do his day-to-day work. Even doctor in his evidence has deposed that due to that disability, claimant is unable to do his day-to-day work. In a class examination of PW1 and PW2 by the defendant respondent, a respondent has not elicited any contrary evidence. Yes. Considering that evidence of PW1 and PW2 and considering that in certificate exhibit P4, I am of the opinion that whole body disabilities has to be assessed 14.5%. The tribunal has assessed monthly income of the claimant as Estimate
25,000, parent 32, my lord.
25,000 per month. And multiplier applicable to the age group which is 17. Accordingly, loss of future earning has been reassessed as follows. Compensation awarded with the tribunal in the other hand. The enhanced compensation amount carries 6% interest. Delay the act. Not first. Yes.
Is it? Family?
Yes.
Lord, the plaintiff's appeal. Application was filed by the plaintiff. 2 applications are filed now. Both under order 39 rule 192.
What?
Lords, one application not to meddle with the property, rather it can be injunction lords not to change the nature of property.
Suit for?
Suit for declaration lords.
One for not to change the nature.
One for not to change the nature of property, another not to alienate lords.
What is that trial court?
Lords, the trial court has dismissed both the applications. Lords, the brief facts of the case are.
What is that order passed by this court here? Interim
Lords,
order.
this honorable court has granted an interim order of status quo.
Less than status quo maintain, I will direct the trial court to dispose of.
No, my lord, Ashma, kindly see here. Lingachari, Chinmachari was the.
Then I will hear.
Yes.
What are agreed, otherwise I will pass an order on merit. When this court has passed an order of status quo.
The status quo order was passed on 7/9/2000.
Yes, 22. Yes, what is your case, Mr.?
May I, sir?
Yes.
Lords, the suit schedule property is survey number 44/1, situated at Hanchia village, measuring about 3 acres 5 guntas.
Yes.
Lords, originally this property was belonging to the father of the dependents.
Yes.
Because the father of the dependents, thereafter the dependents have executed a registered general power of attorney.
Yes.
In favor of the plaintiffs. But the registered general power of attorney is dated 5/2015.
Yes.
Which is registered on 7/5/2015, the next day. In respect of the suit schedule property. Because the total consideration that was mentioned in the general power of attorney is 75 lakhs. Because I have produced the registered GPA at annexure H lots, page 84. Page 84. But under this GPA, the entire consideration has been paid, the 75 lakhs.
Yes.
And possession has been delivered to the
Yes.
My lords, may kindly come to page 80.
Possession has delivered to you.
Possession has been delivered to me.
Then
Lords, the document is at page 88, my lords.
I
possession one clause ಓದ್ತೀನಿ ಅಂತ.
how the possession has go to him.
ಅವ್ರಿಗೆ ಹೋಗಿಲ್ಲ possession.
Then you are seeking that not to alienate, not to.
ಅದು ಒಂದು ರಿಜಿಸ್ಟರ್ಡ್ ಸೇಲ್ ಡೀಡ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾರೆ. ಆನ್ ದ ಬೇಸಿಸ್ ಆಫ್ ದಟ್ ದೇ ಲಾರ್ಡ್ಸ್
No, you have not sought for injunction restraining him to interfere into that possession of the property.
I have kindly
That shows that he is in the possession.
two applications are there. One is not to meddle with the property. I am in possession, don't disturb my possession.
Where is that?
Yes. Lords, claim at annexure B, A at annexure C. Page 49.
See that prior. Not do any development means he is in the possession.
Illa. So any sort of development activity in the scheduled property till disposal of the suit. Lords, may kindly see the affidavit here.
See, if the person who is in the possession, what should be that injunction?
Kindly see, Lords, para 5 of my affidavit. The application has to be read along with the affidavit.
Yes.
Para 5 of the affidavit. May I read?
Yes.
It is my further statement on oath that as on the date of registration of the GPA, defendants have handed over the vacant possession of the scheduled property to me as against the receipt of the entire consideration amount of ₹75 lakhs received by them under the said registered GPA referred to above, and I am in peaceful possession and enjoyment of the scheduled property from the date of execution of the registered GPA with full powers, including power of getting the property to my own name. And, it is my further statement on oath that after the execution of registered GPA as mentioned above coupled with interest, defendant number 1 to 7 have no right or interest over the scheduled property, and they have virtually ceased to hold right holders of the scheduled property in the presence of registered GPA with interest unless the same is cancelled as per law. Thus, the plaintiff being the power of attorney holder with interest is having full power and interest to the exclusion of defendant number 1 to 7 and others. Further, the said GPA, which is coupled with interest, cannot be terminated to prejudice my interest in and upon the scheduled property. From the date of registration of the GPA, I am in actual possession of the scheduled property, and I have placed a hoarding depicting name code and has also fenced front portion of the scheduled property with barbed wire and stones. It is further stated on oath that when things stood thus, in the first week of January 2021, I came to know that some third persons are coming near the scheduled property. Immediately, I arranged for a watchman. Thereafter, all of a sudden, on 10/1/2021, 8th defendant accompanied by some third persons came to the scheduled. When I was in scheduled property, all of a sudden started shouting at me, plaintiff stating that the name placed in the scheduled property has to be removed, and further the stones placed in the front portion has to be removed, and I have to hand over the portion of the scheduled property to the 8th defendant. I was shocked at the attitude of the 8th defendant and his accomplices and informed that I have a registered general power of attorney coupled with interest, and I have paid the entire consideration amount of ₹75 lakhs, and as I have full rights to the scheduled property, you can question my right. The 8th defendant was shocked and demanded to show the registered GPA executed. Immediately, I got the registered GPA, a photocopy, and hand over the same to the 8th defendant. 8th defendant was shocked to see the registered GPA coupled with the interest, and that possession has told me.
Let them show that where you have admitted that the position is. What is that next your case? What is the finding of the trial court?
The finding of the trial court is strangely saying that possession is not delivered.
You said that some
Kindly see
agreement.
para
What is
27.
that agreement? After that, what has happened?
ಇದು ಆದ್ಮೇಲೆ ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ in 2020, notes the very same people who have executed the sale registered general power of attorney along with possession to me, they execute a sale deed in favor of the defendants. 8th defendant, defendant number 1 to 7, they execute a registered sale deed ignoring and suppressing the registered GPA in my favor of the year 2015. But in 2020, 19 to 2020, they execute a sale deed.
Yes.
In favor of the 8th defendant. Yeah. Now 8th defendant is the one who is contesting my application.
When they have executed?
2020, after 5 years of my application, of my GPA, registered GPA.
Then whose name that, is it in Bangalore or outside?
It is in Mysore, my lord.
Mysore.
Yes,
whose name that Khata stands?
Now on the basis of this sale deed, they have taken the Khata in their name.
When?
On the basis of 2020 sale deed, ಮೇಲೆ ಅವ್ರು ಮಾಡಿಸ್ಕೊಂಡಿರೋದು ಈಗ ಖಾತಾ 2021
as on date, sorry to interrupt, as on date the khata is in the name of the
No, I will come to you. See, when the khata has been changed in his name by the purchaser.
2020 ಸೇಲ್ ಡೀಡ್ ಆದ್ಮೇಲೆ 2021 ನಲ್ಲಿ ಅವ್ರ ಹೆಸರಿಗೆ RTC ಮಾಡಿಸಿ.
Where is that? You have to give a correct picture, Mr. That is, see, suit for injunction in respect
Injunction
of,
ಅಲ್ಲ ಡಿಕ್ಲರೇಷನ್.
no,
I have
temporary
sought for-
injunction. No, Mr. When the not suit, the application for temporary injunction, what the court has to see, who are in the possession.
ಹೌದು.
If it is in a constructed building and all, you can see that who are in. If it is in vacant, Supreme Court said you have to see that what are the documents, revenue record stands in whose name as on the filing. That is the document to show that who is in the possession. Now we see that before this land has been alienated by that 1 to 7 to 8, whose name was there, when their name has been changed, when your name was there, what you have done after come to your knowledge. That is the criteria to decide.
ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
That is the point that had to be seen.
But kindly see
If there is a vacant land, then position has to be find out only on the basis of that.
No, lords. Adlu, in case of title dispute, your lordships are right. But here is a case where, my lords, transfer of interest has been done in my favor along with by receiving the entire. My lords, there is a. I'll make this submission. I'll make this submission.
Why?
If there is,
I will tell you, not only on the documents. It is in vacant site. Anybody can occupy any day. Therefore, now that register sale deed is there for 8.
I will come to that. I'll come to
Therefore, revenue records is that major point to be decided. The possession. Suppose if you are really in the possession, somebody's name has been entered into the revenue possession, then immediately you have to challenge. That is that position of law. Otherwise, how the court can be decided? There is a GPA registered in your favor. Sale deed is in his favor. Court has to see on that revenue records and grant an order.
Let's will produce the revenue records.
Yes, he produce. Then will you produce it?
Lord, few facts, Lord, this land originally belonged to Chelvachari. He had two sons. One is Lingachari and Dasachari.
Yes.
My lord, this is extent of land is 3 acres and 7 guttas. Then, my lord, the Lingachari died. Dasachari died. The legal representative of Dasachari filed a suit for partition. Lord, each person got 1 acre 22 guttas. Lord, here the GPA that is sought to be have taken is only in respect of from one side, that is from Lingachari. That is the reason he has paid the legal representatives of Dasachari as the respondents, because they have not sold the land to the petitioner.
Either of them produce the revenue records as on the date of filing the suit. Then before that, your alienation. At any time your name was there, or when his name was there, when it is deleted, when it is come to that notice, that I have to see. Otherwise, I can't say that who is there in that vacant position.
What has happened is, each respondent, the contesting respondent, Lord, he after obtaining the sale deeds from both the parties, he has obtained the sale deeds from both the legal representatives. Thereafter, Lord, Khata changed his name. Thereafter, Lord, entered into an agreement with Buda, Mysore Development Authority, and for a joint development of the land acquisition. And he has developed, and there is an agreement between the Buda and the 8th
No,
respondent.
before 2020,
Yes.
whose name was there in that revenue record?
So,
Before you purchase,
1 to 7.
whether it is in your vendor name or somebody else. That I have to see.
my vendor's name.
That is what I want to see.
Yes.
Where is that records?
At no point of time, my landsman's name is entered anywhere.
What is revenue record? See, before you take property has been purchased, if it is there in his your vendor's name, presumption is your vendor has been in the position.
Yes.
Suppose if it is there in his name, if your vendor has sold without giving in a position, he has sold.
And one more interesting feature is that the power of attorney that has been executed is an admitted fact that the power of attorney has been executed only from the legal representatives of Lingachari, not in respect of Dasachari. That is the case.
I am not deciding the title, whether he has executed it GPA or you are not executed. That is for the declaration. Now only for the injunction.
To know, as of the date of the application, whose name was in the record of right. That way I will.
I want to see that. I can't decide here whether GPA is executed is right, whether this is this property or not. That is not the issue.
Yes, yes.
That's not that.
Blood,
I am restricted only.
along with the list of documents, blood, I'll give the, what is it?
Tuesday. Yes. It is matter on Tuesday.
In the meantime, let minor friend also, my lord, let us not take
Tuesday
time,
or
so that he can produce
if it
whatever the
can be listed, my lords,
document.
after 1 week.
See,
Secondly, I have to secure the.
you better to find it and take it. He is already having a benefit of status quo. He wants to drag.
Lord, what happened, Lord, that is an ex parte order passed by example.
That is true.
In fact, immediately I have filed an application for vacating stay. One reason or the other, Lord, the matter is being urgent.
See,
Now, Lord, the difficulty
that
is,
is not that court has to ask the document.
I follow.
Party should be ready.
Yes.
This is what you have to be
I
argued
have
and
also, I'm not ready to place my hand. I produce it.
1 week, lords.
No,
Any
he
data?
wants to produce Tuesday.
Outproduce ಮಾಡಲಿ, outproduce
then-
ಮಾಡಿ, ಯಾಕಂದ್ರೆ ನಾನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ಬಿಕಾಸ್ ಐ ಹ್ಯಾವ್ ಟು ಸೆಕ್ಯೂರ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್.
Further adjournment ಆಗಬಾರದು ಅಂತ ಅಷ್ಟೇ, ಇದೇನಿಲ್ಲ.
ನಾನು ಯಾಕೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳ್ತೀನಿ?
When do you want
If
to
not,
tell me?
Lord, Tuesday, let him have it on Thursday, that's it, don't matter, Lord. But next time, Lord, we will.
When do you want? Now it
Well,
is
see.
ball is in your court. Yes, when do you want?
Next Thursday, he wants 1 week.
Thursday or Friday?
Friday. Thursday is the motor vehicle. Friday.
Very well.
Yes, leave this matter on Friday.
Let's see, report of the kind.
Interim order granted earlier is extended till next date of hearing.
Insurance, sorry, payments appeal. Injury
Memo
case.
for dispensation R2.
R2, the advocate has filed wakalat voluntarily.
Hmm.
There is no notice.
Who is R2?
Is the insurer vehicle
Liability ಯಾರ ಮೇಲೆ ಇದೆ?
pay and recovery ಆಗಿದೆ.
Pay and recovery ಆಗಿದೆ.
ಹೌದು.
Yes, any of that, if he is voluntarily appeared, it is good for you. Yes. Who is the appearing for that United India Insurance Company?
United India.
ಏನಾಗಿದೆ notice?
Notice ಆಗಿಲ್ಲ.
Yes, United India will take. Nagaraj is directed to take notice for respondent number 1. Internet counsel for the appellant is directed to
Copies served.
serve one set of copies. The wakalat filed by counsel Prakash for respondent number 2 is accepted. Yes, please this matter next week be verified. Yes. Okay. Dispensation any? Why somebody is filed? Why do you want to dispense? ಅವ್ರು ಯಾರೋ ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ಯಾಕೆ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ, ನಾವು ಅಪೀಲ್ ಜೊತೆಗೆ ಹಾಕ್ಬಿಟ್ಟಿವಿ.
ಯಾರು?
ಮೆಮೋ ಪಾರ್ಟಿ.
ಆಯ್ತಾಯ್ತು, now he is there.
Not there.
Yes, memo for dispensation is not present.
Claimant appeal.
Hmm.
But it was impatient for a period of 15 days.
Yes, ready, Mr. Pradeep.
Please, my lord. The tribunal has taken only 12% lot instead of 18%. As disability is a.
ಎಲ್ಲಿದೆ? Discussion ಎಲ್ಲಿದೆ?
Lot of page 20. Bottom disability start. Yes, my lord. Parrot was.
Para 12.
Yes.
Hmm.
Start from the examination TW2 has deposed that the petitioner came to him on 24/22 with an alleged issue of road traffic accident on 31/10/2020 as such right capture one of the factor and after discharge suddenly he was treated at MSRMI hospital particularly with over and
Petitioner has got totally disabilities right arm 54, whole body is 18.
18%.
Tribunal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
12%.
ಹಿಂಗೆ
Same paragraph.
18% ಕರೆಕ್ಟ್ ಇದೆ. ಮತ್ತಿನ್ನೇನು?
He was admitted for 15 days.
54%, 18%, tribunal 14, huh? Come on.
Income is correctly taken, 14,500.
ಮತ್ತಿನ್ನೇನಿದೆ?
And loss of income during later period, only 1 month has been given.
ಎಷ್ಟು ದಿನ ಇದ್ರೆ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ?
15 days. 2 months, another 2 months charge clean.
ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ವಾ?
And future amenities for 17,000 and given, my lord.
Future medical
expenses has been given 60,000 for removal of implant.
ಎಲ್ಲಿದೆ? ಏನಿದೆ ಮೆಟೀರಿಯಲ್ಸ್?
Materials. Evidence of the doctor.
Medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of income during the later period 2 months. ಮೆಡಿಕಲ್ ಅಮ್ಯುನಿಟೀಸ್ 17 ಕೊಟ್ಟಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಫುಡ್ ಅಂಡ್ ನರಿಶ್ಮೆಂಟ್ ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
6%.
Yes, that's all. The council appearing for the claimant has contended that extent it has suffered previous injury. He has examined the doctor as PW2 evidence. He has deposed that claimant has suffered 54% disability to whole body. 54% disability to the right arm, 80% to whole body. As assessed, whole body disability 14% is on lower side.
12%.
12%.
12%.
Is lower side. Also, he has contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 15 days. Compensation awarded by the tribunal for suffering, loss of immunities, or incidental expenses is on lower side. See, Mallikarjun Reddy, the net council appearing for this company has contended that even though doctor has assessed whole body disability is 18%, considering that age and avocation of the claimant, considering that the evidence of the doctor and medical records, really assessed whole body disability is 12%. Secondly, he has contended that the injuries suffered by the claimants are minor in nature. He was inpatient only for 15 days. Considering that the injury suffered by the claimant and considering that medical records awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Not for office. Or to learned counsel for the parties. Is not in dispute. Claimant has suffered an injury. Road traffic accident occurred on 11/11/2020 due to rash and negligent driving of driver of truck bearing registration number KA 42 A8845. Due to that accident, claimant has suffered following injury. Doctor has been examined as PW2. In his evidence, he has deposed that claimant has suffered 4% disability to right arm, 18% to whole body. Considering that age and avocation of the claimant, considering that evidence of doctor and medical records of opinion that whole body disabilities by the doctor 18% is just and reasonable. Accordingly, whole body disabilities is assessed as 18. Tribunal has rightly assessed monthly income of the claimant as ಎಷ್ಟು?
14,500.
14,500. The multiplier has rightly considered as 18. Accordingly, loss of future earning has been reassessed as follows. 18%. Due to that accident, claimant has suffered diagnosed injury, was inpatient for a period of 15 days. But lot of pain during the treatment. Suffered this disability and unhappiness throughout his life. Showing that evidence of doctor and injury suffered by claim to enhance the compensation for loss of immunities from 17,000 to 40,000. Of income during the later period has to be granted for 2 months. Hence, conveniences, food and nourishment has to be enhanced to 3,000 to 20,000. Right, just and reasonable. Accordingly, appeal is allowed in part. Yes. Is that 60?
Case of injury.
2:30. Up list 2.
Next matter, serial number 61, I'm for the appellant. Pray for a week's time, Lord. Inform the other side.
Yes, Mr. Yes. At the request of appellant, use this matter.
Please.
Next week. Yes, next week.
Right.
Yes, Mr. Adida. Then the parties are coming on that day. By adjourning the matter, you are successful in settling the matter. Otherwise, it will be with the waste of the court time also. Then ultimately, party has to go to the Supreme Court and all. Yes. Yavato. 8. ಅದು ನಮ್ಮ ಕೊಡಿ ಅಲ್ಲ ಇವತ್ತು ಬಂದಿದ್ಯಾ 65 yes this matter on 8 ಆಯ್ತು ನೀವು ಬಂದು ಕರ್ಕ ಬಂದ್ರೆ 2:30 will finish it up post this matter for 8 for reporting settlement.
I'm not getting appearance. On the last date of hearing, you lordship. In order. But necessarily that appearance. Connected matters, there are 2 other appeals filed by the applicant here. Although this appeal may be posted along with the other 2 connected appeals.
Yes, Mr.
The defendants are communication.
Difference might be the same. The relatives are different. Properties are also different. Layout is the same. But my submission is the last day. It will not be the matter of being heard. He came in and said that he would take notice and this was posted today. Now, my lord, on that count is no one saying.
No. If you have, it is your appeal. If you have any urgency till next date, then I will hear.
Or what we can do, my lord, is that all they can be given.
No, all 3 others appeal. You are the party. You are the council. Then you are the council. Then will. I can be ಬೇರೆ lawyer ಆಗಿದ್ದು. ಅವರು ನಾಳೆ ಬಂದ್ಬಿಟ್ಟು ನಂಗೆ ಟೈಮ್ ಇಲ್ಲ ಸ್ವಾಮಿ.
All the admitting.
Yes. Please this matter along with the so and so on Tuesday. Tuesday. Yes. Yes. Yeah. Discussion. Ara? ಹಾ
right? Four of both factors.
whole body disability 23%. Criminal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
13%.
23% ಹೆಂಗ್ ಬರ್ತದೆ? 40% ರೈಟ್ ಆರ್ಮ್ ಡಿಸಬಿಲಿಟಿ 40% ಇದೆ. ಹೋಲ್ ಬಾಡಿಗೆ 1/3 ಆದ್ರೂ ಕೂಡ ನಿಮಗೆ 10-15 ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ. ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 15% ಆಗ್ಬೋದು. ಏನ್ ಹೇಳಿದ್ದಾರೆ? Was unable to lift the weight, do his job and truly and examine he was high stepping giant by top. Muscles restricted, right to form arm. Thigh muscles anತಾರೆ only disability has been assessed in the upper limb. What about that lower limb then? Really? ಎಲ್ಲಿದೆ 56%? ಇವಾಗ ಯಾರು Disability 23%. Total additional fine 40%. Whole body disabilities 3%. Total disability of the right lower limb 6%. Activities 40%. According to the total, then they will be added directly to the disability growth and expression part. ಏನು ಈ ತರ ಮಾಡಿದಾರಲ್ಲ, ವಾಟ್ ಇಸ್ ದಿಸ್? ಟೋಟಲ್ ಎಷ್ಟು % ಡಿಸಬಿಲಿಟಿ ಹೇಳ್ತಾರ? 71 into 33 whole body disability says 23%. 71% disability ಬರುತ್ತೆ ಟೋಟಲ್. 3-4 ಚಾರ್ಟ್ ಮಾಡಿದಾನೆ ಬೇರೆ ಬೇರೆ. ಒಂದ್ ಚಾರ್ಟ್ ಇನ್ 40% ಮಾತ್ರ ಮಾಡಿದ್ದಾರೆ. ದೇರ್ ಆರ್ ಅದರ್ 56% ಇದೆ, then 22% ಇದೆ, 31% ಇದೆ. ಹೋಲ್ he has considered 23%. Yes. And yes, disability 23%. ಮತ್ತೆ 26 days. Criminal on 17% ತಗೊಂಡಿದ್ದಾರಾ? 13%. Yes. ಎಷ್ಟು ದಿನ ಇನ್ ಪೇಷಂಟ್?
26 days.
26 13% ಎಲ್ಲಿ ಬರ್ತದೆ? 23%. What is that? He has given any evidence? He himself has appeared. ಏನು ಹೇಳಿದಾನ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಏನು ಹೇಳಿಲ್ಲ. 50% ಇದ್ರೆ we can consider. ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಇದೆ. ನಾನು ಓಡಿಸುವ ಬೈಕ್ ಕಳೆದ 4 ವರ್ಷ ಬೈಕ್ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದೆ. When that is the evidence has been recorded. PW1 evidence 22. Other evidence is structure is reunited. Fracture reunited ಆಗಿದೆ.
Reunited ಆಗಿದೆ.
Fracture is reunited. ಕೆಲಸ ಮಾಡಕ್ಕೆ any amputation ಆಗಿಲ್ಲ, ಏನಿಲ್ಲ. ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಓದ್ತಾ ಹೋದ್ರೆ ನಿಮ್ಗೆ ಇನ್ನೂ ಕಡಿಮೆ ಆಗ್ತಾ ಬರ್ತಾರೆ. ಏನಿಲ್ಲ. So learned counsel appearing for that has contended that due to that extent limit has suffered previous injury. He has examined the doctor as PW2. In his evidence, he has deposed that limit has suffered disability of 71% to the limb and 23% to the whole body. Criminal has assessed whole body disabilities, 13% is on lower side. Other contended that income correct idea. He has contended that
They have 30,000 rupees per month they have earning, but income has been correctly taken, no personal income.
2,500 correct. Yes. Other contended that due to that accident, Clement has suffered grievous injury. He was inpatient for a period of 26 days. He has suffered a lot of pain during the treatment. He has suffered his disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of immunities, and other incidental expenses is lower inside. Hence, he sought for adjustment. For contra, the Learned Counsel appearing for such company has contended that even though doctor has deposed that Clement has suffered 73% disability. Past examination, he has admitted that fractures are reunited. Considering that injury suffered by the Clement and evidence of the doctor, tribunal has rightly assessed whole body disabilities 13%. Further considering that injury suffered by the Clement, considering that medical records and evidence of PW1, compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Hence, he sought for this. Order Arnett Council for the parties. Close. Statement and award. It's not in dispute. Bennett has suffered an injury in a road traffic accident occurred on 9/12/2020 due to rash and negligent driving of driver of car bearing registration number A51 MK 5562. Due to that accident, Bennett has suffered the following injury. Doctor has been examined as PW2. In his evidence, he has deposed that Bennett has suffered 71% disability to his limb. Considering that evidence of doctor and injury suffered by the claimant, considering his avocation and age, I am of the opinion that whole body disabilities has to be assessed. Our contention, whole body disabilities has to be assessed 23%. The tribunal has rightly assessed notional income as 14,500. 15,000. 14,500. The multiplier applicable to that age group is 18. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, Bennett has suffered the following injury. He was inpatient for a period of 6 days. He has suffered a lot of pain during the treatment. He has to suffer disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, he claimed to enhance the compensation loss of abilities from 20,000 to 40,000. Loss of income during the later period has to be granted for 3 months. Compensation awarded by the tribunal in the other hand are just and reasonable. Yes, tell the doctor.
90,000 they have no medical.
ಏನು ಕೊಟ್ಟಿಲ್ಲ ಏನಕ್ಕೆ 90,000 ಇದೆ ಏನಾಗಿದೆ ಏನಾಗಿಲ್ಲ ಫುಡ್ ಕ್ರಾಪ್
There is no estimation bill.
Another surgery for removal of the implant and the foot drops status transfer. The essentially this surgery is around ₹90,000. It is 90,000. Have you undergone surgery? You have not undergone any surgery. Yes, correct. ಅಷ್ಟೇ ಇರೋದು.
Yes, 6%.
61 adjourned, number 62, because norms are applied.
Not found you are challenging. Quantum. Notice. We have coordinated 4th July 2023 passed by SCB Bank in MEC 2293 of 2020. It's subject to deposit of 50% of the award amount with interest before this court within 4 weeks.
Number 54, are applied.
Yes. Yes. Yes.
Is 1.35 crores, including allotted this page 37.
Yes.
To relieve the distribution. 2.52 crores.
Why that amount due?
I got the amount. they defend the defendants, they do them for a long time, against the right.
Hand loan.
And the defendants are building a house.
Yes.
They fell into trouble, they were not able to complete it. Out of total minority, they regularly contributing money to the minority. Please see from page 6 onwards. All the amounts are by check.
What is the total amount?
Total amount is 1,35,800 rupees. Page 10. Putting interest is what we are claiming. The defendant minority, the respondent credit, refused to clear the sum. So we moved the court method. Suit for recovery was filed. Along with that, claim under order 35, order 38 was 5 and 6 months of time. That's at page 32. Attachment before judgment. That application will not came to be dismissed. If you notice at page 17, before I take that number, can at least take a look at the counter file. Because there are admissions in the counter. Page 122.
Yes.
Counter file that we have to put in dependence of the application. The lot in PCI, para 3.
Yes.
Admittedly, my lord, there has been mortgage.
Property on which the attachment order is sought for application.
It's already mortgage by the Canara
Bank.
And my lord, please, 13 months, 2022. Lord, please come to page 125. The bottom of that para. In total, the applicant has paid a sum of rupees 1,35,800 rupees towards part advance sale consideration for the sale of second floor of summation. So the amount is separated. But the defendant takes the stand that this amount that was loaned is actually not in loan, that it was part payment for purchase of the, which we are completely denied. We are only getting loans with them. When all the fees come to parent 12 as well. He had gone into the apprehension that they are going to pay a third party interest. This is their reply. It is denied that the applicant paid.
Where you are reading?
Page 126. The counter action.
Yes.
They now given to understand that police defendants are making complete attempts to dispose of the scheduled properties, inclusive of the superstructure standing there in favor of third parties, so as to defeat and delay the recovery proceedings initiated by the applicant against the opposing defendants. The Lord, please come to skip the next line in the center of that page. It is true that all the opposing defendants are not having any other properties. So 1.35 crores is admitted. There is no other property that the defendant has. Defendant says that we are not paying anything. Despite that, the order came to be passed.
Where is that admission? He is not going to alienate.
Para 12. Para 12. The applicant plaintiff now given to understand the Reliance Sources and the opponent defendants are making frantic attempts to dispose of the scheduled property, inclusive of the superstructure standing there in favor of both parties, so as to defeat and delay the recovery proceedings initiated by the applicant plaintiff against the opponent defendants. My lord, please see the impute order actually. And its impute order starts at page 17. The arguments of the defendants, my lord, please see page 23.
Yes.
Of the paragraph page, the defendants are admitted. The defendants are admitting the fact that we are not have any other properties, but deny that we are likely to encumber the same property and alienate the scheduled property, bit by bit in favor of third parties, so as to defeat and delay the execution of the decree likely to be passed in the lawsuit. My lord, the other reasoning, so this was the argument that they do. The trial court, my lord, its reasons from page 28. Page 28. Point number 1. The suit of the plaintiff is for recovery of money for hand loans raised by the defendants from the plaintiff in support of the application. The plaintiff has furnished the details of transaction in the second. The evidence at page 4. The said transactions are given in daily as shown in the payment given in the past the other hand, the defendants admitted the above transactions, denying the DP notes as made by the plaintiff in his elements. The defendants contended that there is that as per the oral agreement executed between the plaintiff and the defendants for purchase of the second floor of submission covered by the plaintiff, the plaintiff has given the same consultation would part by part to the defendants. This my lord is the reasoning. Lord, please see the amounts that have been given. Page 6. This is all admitted, my lord. If I check, the first amount that was given was 43,080. Page 6.
Now, why that your application is rejected?
Because rejected para 10 member. The defendants to substantiate the contentions based on objections that the non-court is not valid. My lord, let's skip that. The plaintiff prima facie established that the transaction showed in the date as well as the documents is paid to the defendants. That is one part. Para 11 on this. My lord, please note there are two promissory notes that have been executed. Page 65 please. Page 66. The first one is dated 23/2021. Demand promissory note providing for interest. Page 65.
Yes.
My lord, please note the date. This is important. 22/3/2021. The agreement, oral so-called oral agreement, my lord, as per the defendant at page 125 is 28/3/2021.
No, they are giving date that is oral.
And they say it's oral, my lord. And even the oral date that they give is 28/3/2021. Prior to that, my lord, I have given handbook to the defendant only because I know the defendant, I care for the defendant. I don't have the defendant, my lord. And it's a very bad shape because lots of things are going to happen. It's out of my even, my lord, that I help the defendant out. And instead of repaying me, my lord, now the defendant turns around and says that yes, you give me the amount. Yes, we are not going to alienate the property at this juncture, but we are going to oppose your application. The bona fides of the defendant, my lord, they should not have any difficulty with the application being allowed.
Yes.
My submission, my lord, PC page 65. This is the demand promising. Defendants, my lord, are one and
No, why do you want for attachment? You let him direct, not to create.
yes, my lord, no third party interests are the defendants of the defendants. That is totally nice. As far as the application filed itself, it is not to alienate under order of the a prayer without the prayer, they are not sought for any. They filed an application under order 38/5 for attachment of under order 38/5 scheme. Whether a unsecured debt can be made a secured debt by means of attachment. That is the crux of the bill. He says not even if it is settled, nothing going to happen. That is not the scheme of it. The rate rules 5. Not rule 5 of order 13. Yes. Where at any stage of the suit, the court is satisfied by affidavit or otherwise, defendant the intention to obstruct the delay in the execution of any degree that will be passed against him is about to dispose of whole or any part of the property, or is about to remove whole or any part of the property from the local limits of the jurisdiction of the court. The court may direct defendants within the time fixed by it either to furnish security in the sum aspect specified in the order or to use the disposal of the court required property of the value of the security or such portion thereof which is sufficient to satisfy the or to appear and show cause why it should not furnish the security. The plaintiff shall, unless the court otherwise where it specifies,
and property so and so. But A and B are the primary ingredients which has to be satisfied. Even in the application, that has to be interpreted by the Supreme Court. I will cite the
What is
judgment.
that? Degree that may be passed against him about to dispose
Yes,
of the
yes.
whole or any part of his property.
Correct. But what is this
About to
application?
remove whole or any properties.
Correct.
Yes.
There should be when security is not furnished, then 6 would apply. Therefore, the primary ingredient is that there should be a threat that is going to dispose of the property. This threat is invalidated because the property is already mortgaged with the Canara Bank deposited title deed. Secondly, this application is as vague as it does not satisfy with the ingredients of.
Now, where is the document to show that it has been mortgaged with the?
But I have produced before the court.
No, that mortgage with title deed. Where is that? If you produce that, yeah, see, you have to see what is that mortgage, what is the term.
ಆಯ್ತು ನಾನು ನಾಳೆ tomorrow.
ಯಾಕೆಂತಂದ್ರೆ
ನಾನು ತರಿಸಿದ್ದೀನಿ.
ಅದು ಟರ್ಮ್ ಏನಾರ ಇನ್ನೊಂದು 5 ತಿಂಗಳು 6 ತಿಂಗಳು ಇದ್ಬಿಟ್ಟು ಆಮೇಲೆ
ಇಲ್ಲ.
if it is indefinite, then he cannot alienate because
even otherwise, I satisfy your lordships that Lord 38 is not satisfied. You have to judgments of getting of judgments of the Supreme Court as well as
tomorrow.
Defendant admits that such an amount.
No, that is true. The application you have filed and remedy seeking only under 38. You could have filed under 39, 1 and 2. It's in a different. That is the.
In the interest of justice,
You file an application 39, 1 and 2.
liberty and that liberty will be granted.
That
But
will be
liberty may be
I mean, this was a, no, now that is nothing but allowing that your application. See, if I grant such an order, it's nothing but allowing that application. Now that so no, until Allah. See, even now that if you show that it is already mortgaged, you are not entitled for that relief at all. Therefore, by another 1 month, nothing will happen. It is with the bank. By the time you file an application and get it, yes, tomorrow. Yes. I will also direct if such application is filed to decide because both are present, appear before court may be decided. Yes, yes. No, to pass an order under this provision, court has to look into that, under that ingredients under that. 39, 1 and 2 is different.
Pass to the matter, number 1, serial number 20, Swaroop P. Malapalat, connected matter to Odisha.
Yes, what is this, Mr.
As my lordship. The question, the judgment and award of the LSC reference court, my lordship. I made a cross objection claiming that we have relied on the judgment of passed in LSC number 15/2000.
No, what is that award passed by that land acquisition officer?
My lordship, land acquisition officer passed an award at the date of this 1,01,871, my lordship.
1 lakh
Sorry, my lordship.
per acre.
Per acre, my lordship. It has been enhanced to 2,77,200
In that reference.
reference code.
Now that what is your appeal?
My appeal, my lordship,
Further enhancement.
because my lordship, I relied on the LIC number 20/2012, wherein my lordship, 2,77,000 was awarded.
In respect of very same.
Yes, my lordship. Subsequently, my lordship, and that the LIC 15/2012, it has been enhanced to 3,88,000. by the district and session court.
In the same
The same LIC 15
in case ಅಲ್ಲಿ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ 2 lakh
2,77,200 ಮಾಡಿದ್ರೆ. Relying on LIC 15 of 2000.
I think subsequent case
Subsequent appeal ನಲ್ಲಿ it has been enhanced to 3,88,000.
3,88,000 ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ ಅವರು
80 rupees. That is not challenge.
ಅದನ್ನ ಬಿಟ್ಟು ನಿಮ್ಮದನ್ನ ಚಾಲೆಂಜ್
ಅಲ್ಲ. That is for the Hemavati canal it has been. Adjacent village land lordship. Hemavati canal.
ಇದರಲ್ಲಿ ಇದೇ ನೋಟಿಫಿಕೇಶನ್ ಇದೇ ಪರ್ಪಸ್ ಆಗಿರೋದ್ರಲ್ಲಿ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ?
Iದೇ purpose this is for the market lordship, APMC market.
Then you have to examine whether then they are also challenging that
2,77,000.
ನಿಮ್ ಕ್ಲಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಏನಿದೆ? Condemnation of delay 6 days. Yes, who is appearing for this thing?
So Swarup has today directed to take notice for us. For R1.
Swarup R1.
Yes, my lordship.
Yes.
Government advocate for R2.
He is directed to take notice for R1. Government advocate is directed to take notice for R2, 3 and 4. 3 and 4. 3, 4. The net counsel for the opponent is directed to serve the copies to respective counsels.
Other 7 matters are there, my lordship. There have been 7 matters. My cross appeals.
Yes. Post this matter along with that sounds. Okay. ಅದರಲ್ಲೆಲ್ಲ ಏನಾಗಿದೆ? ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಅದರಲ್ಲೂ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ. ಫಸ್ಟ್ ಟೈಮ್ ಬರಬೇಕು.
Post this matter along with that so and so after 2 weeks.
Other matters have been posted on Monday.
Monday.
My colleague.
Yes, post this matter along with the so and so after second. Yes. Now, what is that? You have filed in a memo. What is the case? Will dispose of.
In case of death, your
Wow. What is that age of the deceased?
52 years.
52 years.
52 years.
Liability and dispute ಇಲ್ಲ ಅಲ್ಲ?
ಏನಿಲ್ಲ. Only income.
Income ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
6,000 ತಗೊಂಡಾರೆ 2015 accident.
ಅವ್ರಿಗೆ ಎಷ್ಟು ಕ್ಲೈಮ್ ಎಲ್ಲಿದೆ ಡಿಸ್ಕಷನ್?
9,000.
Is not 9,000. ಅವರು 10,000 ಕೇಳ್ತಾರೆ. ಕ್ರಿಮಿನಲ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 6,000. ಯಾವತ್ತು ಆಕ್ಸಿಡೆಂಟ್ ಡೇಟ್?
2015.
2015. 9,000 ಇದೆ.
Not prove the income. Income prove ಮಾಡಿ.
ಏನಿದ್ರು ಇದು ತಗೊಂಡ್ಬೇಕಲ್ಲ. ಆಮೇಲೆ ಎಷ್ಟು ಏಜ್? 52.
52.
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕೊಟ್ಟಿದಾರ?
10%
ಹಾಕಿದಾರ ಅಲ್ಲಿ? ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಕೊಟ್ಟಿದಾರಲ್ಲ?
ಕೊಟ್ಟಿದ್ದಾರೆ. 10%.
ಕೊಟ್ಟಿದ್ದಾರೆ. added to the income 600. Then what is the deduction?
Election
50% ಮಾಡಿದ್ದಾರೆ. ಯಾಕೆ?
50%.
50% comes
50% major son your 2 and 3 not a dependent. Sons 22 years and 27 years.
ಆಯ್ತು, ಮೇಜರ್ ಆದ್ರೆ they are depending. You can't say that they are not depending. ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲಿ ಇದಿದೆಯಾ? ಎವಿಡೆನ್ಸ್ ಇದೆಯೇನಮ್ಮ? PWD ಎವಿಡೆನ್ಸ್ ಇದೆ, ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ. ಮಾತಾಡಾಗ್ಬೇಕು.
ಅಂದ್ರೆ ಅವರು ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವರೆಲ್ಲ ಸಪರೇಟ್ ಇದ್ದಾರೆ.
ಜೊತೆಗಿಲ್ವಾ?
ಸಪರೇಟ್ ಇದ್ದಾರೆ.
ಆಲ್ ರೆಸಿಡಿಂಗ್ ಇನ್ ದಟ್ ಸೇಮ್ ವಿಲೇಜ್. ಎವಿಡೆನ್ಸ್ ನೋಡೋಣ. ಎವಿಡೆನ್ಸ್ ಮಾಡಿರೋದು ಯಾರು? ಹೇಮಪ್ಪ ರೆಡ್ಡಿ.
ಮ್ಯಾರೇಜ್ ಆಗ್ಬಿಟ್ಟು ಸಪರೇಟ್ ಆಗಿದ್ದಾರೆ.
ಅಲ್ಲ, ಸತ್ತೋಗಿರೋದು ಯಾರು? ವೈಫ್ ಹ್ಯಾಸ್ ಡೆಡ್.
ಓನ್ಲಿ ಹಸ್ಬೆಂಡ್ ಇಸ್ ಡಿಪೆಂಡೆಂಟ್.
ಕೇಶವ್ ರೆಡ್ಡಿ ಅವರು. Let us see that evidence. Above against the respondent, motor vehicle so. Again, that 10,000 per month that the deceased was earning member of the family and maintain the family during the said. We are all depending upon that her income. Class examination in
ಅವರೆಲ್ಲ ಕೆಲ್ಸಕ್ಕೆ ಹೋಗ್ತಾರೆ, ಬೇರೆ ಬೇರೆ ಇದ್ದಾರೆ. Earning member. 3 is earning member.
ಗುರುತು ಶಾರದಮ್ಮವ್ರಿಗೆ ಯಾವುದೇ ಉದ್ಯೋಗ ಇರುವುದಿಲ್ಲ. ಅವರು ಓದಿದಂತೆ ಕೆಲಸ ಮಾಡುತ್ತಿರುವುದಿಲ್ಲ. ಯಾವುದೇ ಉದ್ಯೋಗವನ್ನು ಮಾಡುತ್ತಿರುವುದಿಲ್ಲ. ನಾನು ಮತ್ತು ಶಾರದಮ್ಮ ಅವರು ಮಾಡ್ತಿದ್ದ ಅರ್ಜಿದಾರ ಪದವೀಧರ ಅರ್ಜಿದಾರರು ಎಂದು MBA ಪದವೀಧರಾಗಿರ್ತಾರೆ. ಈತನ್ನು MBA ಮತ್ತು ಬೆಂಗಳೂರು ನೌಕರಿ ಮಾಡ್ತಿದ್ದಾನೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. SSLC ಪಾಸ್ ಆಗಿದ್ದು ಹೊಲದ ಕೆಲಸ. ಒಬ್ಬ ಮನೇಲೇ ಇದ್ದಾನೆ.
ಇದ್ದಾರೆ, but not good.
ಈಸ್ ವಿತ್ ದ ಫ್ಯಾಮಿಲಿ.
MBA ಅಂತಂದ್ರೆ ಕೆಲ್ಸಕ್ಕೆ ಹೋದೇ ಹೋಗ್ತಾರೆ. MBA ಅಂತಂದ್ರೆ
ಅವನು ಒಬ್ಬ, ಇನ್ನೊಬ್ಬ SSLC ಫೇಲ್ ಆಗಿದ್ದಾನೆ. ಅಲ್ಲಿಗೆ 1/3 ಬರ್ಬೇಕಲ್ಲ, 1/4 ಆಗಲ್ಲ, 1/3 ಬರುತ್ತೆ. ಅದರ ರೇಟ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಆಯ್ತು. Don't show learned council appearing for
interest is higher side. 9% trial court is awarded.
enhanced is 6%.
Yes.
Don't show learned council appearing for the claimant has contended that time of the accident it was earning 10,000 per month. As consider notional income of the claimant as 6,000 per month is on lower side. He further contended that there are 4 claimants, they are entirely depending upon the income of the deceased. The tribunal, instead of deducting 1/4 of the income of the deceased for personal expenses, has deducted only 50%. He further contended that view of judgment of apex court in case of magma, claimants are entitled 40,000 each, sought for enhancement of compensation. Don't show learned counsel appearing for the claimant insurance company has contended that even though claimant has claimed that deceased was earning 10,000 per month, they have not produced any document to establish the same. Tribunal has rightly assessed notional income of the claimant as 6,000 per month. Further contended that the claimant's number 2 to 4 are major sons. They are not depending upon the income of the deceased. Therefore, tribunal has rightly deducted 50% of the income of the deceased for expenses. Lastly, he has contended that the interest awarded by the tribunal, 9% is on higher side. He submitted that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable, not for dismissal of the appeal. But the learned counsel for the parties heroes, judgment and award. Dispute. Claimant has claimed that deceased was earning 10,000 per month. It is not in dispute. What is that name of the deceased? Sharadamma died in road traffic accident occurred on 1/12/2015 due to rash and negligent driving of driver of Honda motorcycle bearing registration number TN37 CD 8652. Even though claimant has claimed that it was earning 10,000 per month, they have not produced any document to establish the same. Under the circumstances, the notional income has to be assessed
9,000
as per the guidelines issued by Karnataka Legal Service Authority for the accident occurring 2015. Notional income has to be considered as 9,000. Tribunal has rightly added 10% of the income of the deceased for personal expenses. Even though there are 4 claimants, the claimant number 1 and 3 are
Team. One is a husband, TW2 is the son. Team. Team.
The claimant number 1 and claimant number 3 are residing with that deceased, and they are entirely depending upon income of the deceased. So 1/3 of the income of the deceased has to be deducted for personal expenses. The multiplier applicable to that age group, what is their age?
Age 52 years.
11. Accordingly, loss of dependency has been reassessed as follows. Addition, 15,000 for loss of estate, 15,000 for funeral expenses. Leave of
545, ಇನ್ನೂ 40 ದಿವಸ delay ಇದೆ, not carry interest.
Yes.
45 days.
Yes. In view of judgment of apex court in case of Magma, first claimant is entitled 40,000 for spousal consortium. 2, 3, 4 are entitled 40,000 each.
My lord, so recent Supreme Court is only once
ಎಲ್ಲಿದೆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ, ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಎಲ್ಲರ ಹತ್ರ, ಕೊಡಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ. There is no ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಯಾವ್ದೋ ಒಂದು ಕೊಟ್ಟಿದ್ದಾರೆ, there is no discussion at all. ಅಲ್ಲಿ ಏನು ಹೇಳೇ ಇಲ್ಲ. I have gone through, ಯಾವ್ದೋ ಒಂದು ಕೊಟ್ಟರು ಅದ್ರಲ್ಲಿ ಏನೂ ಇಲ್ಲ. Yes, 40,000 each. In view of order dated 25/11/2022, the claimant is not entitled for the interest for a period of 545 days. Yes. All pending applications.
enhanced amount 6% interest.
Yes, enhanced. Compensation amount carries 6% interest. Yes. 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 7 days. Yes. ಡಾಕ್ಟರ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ? Yes, that is reasonable. Yes, income. ಎಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ? 3 days, 7 days in the inpatient. What are that other head? Parents suffering. Yes. Error period 3 months ಕೊಟ್ಟಿದ್ದಾರೆ. Now it has to be enhanced cover. Yes. Interest percentage. Yes, that's all. No, that you have not challenged. Yes. So learned counsel appearing for claimant has contended that the time of the accident, claimant was earning 20,000 per month. Tribunal has assessed the income of the claimant as 9,000 per month is on lawyer side. She further contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 7 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. compensation awarded by the tribunal for loss, pain and suffering, loss of immunities, and other incidental expenses is lower side. Hence, he sought for enhancement of compensation. For contra, what is your name, Mr.
Rajendra.
Rajendra? The council appearing for Hegde has contended that even though claimant has claimed that this was the claimant was earning 20,000 per month, they have not produced any document to establish the same. Therefore, tribunal has rightly assessed the notional income of the claimant as 9,000 per month. Further contended that the whole body disabilities assessed by the doctor is on a higher side. The tribunal has error in considering that whole body disabilities 8%, which is on higher side, considering that injury suffered by the claimant. Therefore, he contended that the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 7/1/2017 due to rash and negligent driving of driver of motorcycle bearing registration number AA33 H5186. Due to that accident, claimant has suffered the following injury. Considering that evidence of doctor, the tribunal has rightly assessed whole body disabilities 8%. Even though claimant has claimed that he was earning 10,000, 15,000 per month, 20,000 per month, they have not produced any document to establish the same. In view of guidelines issued by Karnataka Legal Service Authority, the accident occurred in 2017. Personal income has to be considered as 11,000. The time of the accident, limit was aged about
8 years.
8 years. Multiplier applicable to the age group is 9. Accordingly, loss of future earning has been reassessed as to. Due to that accident, the limit has suffered the aforesaid injury, but inpatient for a period of 7 days. He suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, claim to enhance the compensation for pain and suffering from 15,000 to 40,000. Loss of immunities from 20,000 to 35,000. Loss of income during the later period is granted for 3 months. Accordingly, appeal is allowed in court. Yes, dispense with article 11. Period. In view of order dated 17/4/2023, not entitled for the interest for a period of 97 days.
For appellant, page verify ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ dispose
ಆಗಿದೆ. As for that, trial court records, suit itself has been disposed of. None appear for the appellant. The appeal itself will not survive for consideration. Appeal become infructuous. Accordingly, dismissed as become infructuous.